today and tomorrow. So I will be acting chair, and I stress the acting. God bless her. She works very hard. So we're going to begin this morning. It is 9:01. I'd like to begin um, with, as is on your agenda, House Bill 142.
Oh, Representative DeSimone, do you have the beginning script?
I do not.
Let me get that to you.
And Representative DeSimone, I will take attendance after you read that.
Oh. Christine, how are you going to get that to me?
I'm going to send you an email so you can read it from your computer.
Oh my goodness. Okay, I'll try.
If that we'll see if that works.
Christina. Christina Dyer.
Yes, I'm sorry. I'm running two meetings at the same time, so I apologize.
No,
Yes.
no, that's okay. This is Representative Wazir. Can you send a link to Representative Grossman?
Yes, absolutely. I'll do that right now.
Thank you so much.
Thank you, Christina. I got it.
Caroletta?
Yes.
Hi, good morning. Do you, I had requested, I don't know if Karen is on this call or if that was just her that ducked off as I was coming in. But are you getting the blue sheet sign-ins to your email?
Okay, so they don't come in color to me.
But you know what I mean, the sign-ins, just the for and against.
Yes.
You are?
Wait a minute. You mean that from the public or from the committee?
The public.
Okay. Good morning.
No, I do not get them.
Okay.
Good morning.
Good morning, Deborah. How are you?
I am well, thank you. Representative Altschuler, how are you?
I'm good.
I'd like to start this morning's meeting now by reading the script that we were given. As acting chair of the Children and Family Law Committee, I find that due to the state of emergency declared by the governor as a result of COVID-19 pandemic, and in accordance with House Rule 67 and the governor's emergency order number 12, pursuant to Executive Order 2020-04, this public body is authorized to meet electronically. This is a public hearing on bills referred to the committee. An executive session may follow. Please note that there are no physical locations for members of the public to observe and listen contemporaneously to this meeting. However, in accordance with the emergency order, I am confirming that all members of the committee and select legislative staff have the ability to communicate contemporaneously during this meeting through the Zoom electronic meeting platform. Excuse me. And the public has access to contemporaneously listen and, if necessary, participate in this meeting by Zoom platform or by telephone. All necessary access information has been made available in the House calendar and through electronic calendar on the General Court website. The notice for this meeting notice complies with House Rule RSA 91-A. Anyone who has a problem accessing the meeting should call 271-3600 or email legislative services by, the email is hcs@leg.state.nh.us. In the event that the public is unable to access the meeting will be adjourned and rescheduled. Christina Dyer is the staff assisting us. Please note that all votes that are taken during this meeting shall be done by roll call vote. We will also start the meeting by taking a roll call attendance. When each member states their presence, please also state whether there is anyone in the room with you during this meeting, which is required under the right to know law. I thank you.
Thank you. Good morning, members of Children and Family Law.
I recognize Representative Alisea to take the roll call.
Thank you, Vice Chair DeSimone. Representative Altschiller,
Here, and I am in Stratham alone in my office.
thank you. Representative Belanger. Representative Cross. Representative Grossman.
Here, and I am in my studio in Exeter.
Are you alone?
I'm alone. My husband's in the house, though.
Thank you. Representative Levesque.
I am here. I am in my spare room alone.
Thank you. Representative Lewicki.
I am here in the committee room.
Representative Litchfield.
I am here. I am at home, and I do have several family members that are here.
Representative Long.
I am here in my house alone.
Representative Petrigno. Representative Rice has been excused. Representative Smith. Representative Wazir.
Good morning. I am home with 3 of my own children and my little brother.
Thank you. Representative Yokella.
I am here in my home alone. Thank you.
Thank you. Vice Chair DeSimone.
Good morning. I am here in room 210-211, and I am with Representative Lewicki.
Thank you. And Representative Alisea, I have a house guest that's coming in and out, and a puppy. Thank you. All set. Thank you.
We all set, Representative?
Yes.
Thank you. Good morning, everyone. This morning, we're going to start with House Bill 142. This is a bill that was brought to you by me. So after this, if anybody has any questions, I can answer your questions, but I will not be asking any questions. We do have one person to testify after I open the bill. So with that, I would like to open House Bill 142. House Bill 142 is relative to causes for divorce. If you look at the bill, what we're doing is on Roman numeral 7. We are adding and correcting the verbiage of this bill. So it will say when either party habitually abuses alcohol or drugs and has been doing so for 2 or more years. I feel that this will clarify that cause of divorce more so than what was already there. And with that, I will open to testimony. We have, and I will open her in 1 second. We have Mindy Green, and I will let her speak. Where'd she go?
Vice Chair DeSimone, does she have a testimony?
I will get to that in 1 second. I'm trying to open her and having difficulty. Please bear with me.
Oh, yes, thank you.
Christina, I'm having trouble opening these people.
Okay, are we looking for Mindy Green? Is that right?
Yes, I see her,
There we
but
go.
my system won't allow me to open.
Okay, there you go.
Good morning, Ms. Green. Can you unmute yourself? Good morning, Ms. Green. Can you unmute?
Ms. Green, if you can hear us, you can also press the space bar to speak if you're having trouble unmuting. You'll have to hold it down though.
Good morning.
Good morning, Ms.
Good morning.
Green. How are you this morning?
Good. I apologize. I'm having technical difficulty. Can you hear me?
Yes, if you're on a second device, oh, there you go. Perfect.
Yes, I apologize. I greatly apologize for that. I don't know what the issue was. My name is Mindy Green. I'm in Derry, New Hampshire. Thank you very much, representatives, for allowing me to speak today. I've never done this before, so forgive me if it's not exactly the right thing, but at here is to revise the wording for a fault divorce. And my understanding was that adding the sexual misconduct phrase was also part of this bill. My understanding was that the law simply states the law right now as it is, that adultery can only occur between a man and a woman. I'm talking to you today because I'm going through a divorce and I'm in a gay marriage, and my wife committed the adultery. When I submitted my testimony for the hearing to the judge, It was thrown back because adultery in the state of New Hampshire is only between a man and a woman. We fought for marriage rights, so straight couples have the right to marry, and then gay people have the right to marry. So we have the right to marry, but we do not have the right to divorce in the same manner. I was thrown back all of my exhibits, and the lawyer on the opposing side from Concord was able to get lawyer fees out of me when it's his client that did the adultery. I find it completely discriminating that we are allowed to marry, but we are not allowed to base our adultery, cause of divorce for adultery, just because we are two women. When I talked about this to in the hearing and to my lawyer and to the judge, the lawyer was very patronizing and told me, well, that's the law. You want to do something about it? I guess go to legislation. Well, here I am. I don't know what I can do. I'm hoping that this bill with the sexual misconduct phrase would allow me, if this became law, to resubmit my divorce claim on the basis of adultery, grounds with adultery, because I can use the sexual misconduct phrase for a woman and a woman. It is unfair how far our gay rights have come, and yet I am still discriminated against in my divorce proceedings. My final hearing is not until June. I don't know if anything would happen in a timeline where I can resubmit my claim of adultery, grounds for adultery in my divorce hearing. But if not, and I unfortunately had to pay fees, which I did not think was fair, I'm hoping that future gay and lesbians that have any issues in a marriage, adultery is adultery, just like marriage is marriage. Man to woman or man to man. So I may not be clear exactly what this hearing is. It seems like after the opening of the bill that it's just to change the wording for the 2 years. And that seems fine to me. It makes the wording more clear. So I support that bill that you're looking at today. If anybody can help provide any other information to me as far as what I'm not reading correctly, if the sexual misconduct is already in law, I don't think it's already in law as far as what I was looking at. So that's all I wanted to say. I thought this was a proper place that I can do some outreach. I've emailed a couple of representatives, but I understand people are busy. I have not gotten any personal responses except for maybe one. I'm trying to find anybody in legislation that would help me. This is not right in the LGBTQ community. Thank you very much for your time.
Thank you, Ms. Green. Do you have written testimony that you can submit, please?
I can do that, yes.
Thank you. And also, I think that if you hang on, the next person that I'm going to call is Attorney Jay Markell, and he will discuss the other portion of the bill that you're talking about, to remove certain words so that sexual misconduct of either party, which includes the following, and it no longer specifies man, woman. So I think if you listen to Attorney Jay Markell, it might help you.
Thank you.
Madam Chair and Representative Alicea, this is Representative Cody Belanger. I pardon the interruption. Just wanted to let you know I am present in my car on my way to Concord. I apologize. I had an appointment that I needed to make.
Thank you, Representative. You will be marked present when you get here. And I forgot to ask, does anybody have any questions for Mindy Green?
I do. Madam Chair, I raised my hand in the chat. Where would you like us to notify you that we have questions?
No, you did it correctly. I'm new to this, so
No worries.
I am asking your indulgence. So
No worries.
go ahead, Representative Altschuler, go ahead with your question.
Thank you. Okay, I'm unmuted again. Thank you for taking my question, Ms. Green. And I'm wondering, are you aware at this time that this particular problem that you are experiencing right now within the judicial system is actually being addressed at the Supreme Court right now? There is a case that is going through the court that would address your issue. And so there is going to be there will be a finding probably within the next few months that will address this exact issue. That will probably come out before any legislation could finish winding its way through this process.
Thank you. Do you have the information? I could research that, the case name or anything?
I believe the case name is Blaisdell.
Thank you very much, Representative.
Sure. Yeah, so it's there right now.
Excellent.
Thank you, Representative Altshuler, and thank you, Ms. Green. The next person we have to speak is Attorney Jay Markell. He will be able to help you to understand this bill even further. Attorney Markell, are you ready?
Yes, yes, Representative DeSimone, I am.
Go ahead.
Okay, thank you for hearing me. I'm sorry for joining the meeting somewhat late. So if I came in on the tail end of that, and it was my understanding that in support of this bill, somebody who just testified indicate that they were in a same-sex marriage and that there was the type of sexual misconduct described, which is described in House Bill 142. If somebody, what we were basing this bill on was, first of all, not only the traditional notions of what constituted sexual misconduct was, but also on the way the New Hampshire Supreme Court had previously treated claims of what adultery was. Specifically, in the case of Inree Blanchflower from 2003, the court turned down the notion of adulterous conduct when one of the parties was engaged in basically a same-sex sex practices. Okay, in other words, what the New Hampshire Supreme Court said was adultery gets its common ordinary interpretation, which at that time required sexual intercourse defined as traditional heterosexual intercourse between a man and a woman. Just by way of trying to clear some of this stuff up, last night I emailed a copy of a New Hampshire Bar News article that I had done, which described more generally these issues for the committee. That was done, I think, in November of last year regarding this legislation. What you have here is more generally is bringing same-sex couples and I'm going to say traditional couples, heterosexual couples, more in unity, because what it does is it gives them mutuality and commonality of remedy. What you have here is a situation where people who are engaging in sex practices that do not implicate sexual intercourse nevertheless have the same remedies. So this is actually does, for want of a better term, level the playing field and try and provide true sexual equality. Because what it does is it gives the commonality of remedy, because it applies not only to same-sex couples, but also applies to traditional couples as well. Now, what we do here, if you read it, we borrow from the felonious sexual assault statute that already exists. The one difference here is that as you read it, is that there has to be intentional touching, which could be reasonably construed for the purposes of arousal or gratification. Now, that's an important protection, because people who have either a laying on of hands for therapeutic reasons, which could protect doctors, obstetricians, gynecologists, proctologists, and people like that, are doing that in the course of their profession. So this could not be construed for that reason. So it has a necessary protection in it. I'd be happy to entertain any questions the committee may have on this issue, if there are any.
Thank you, Mr. Markel. We do have one question. I'll get to that person momentarily.
Okay. And
that would be Representative Long.
okay. Yes, Representative Long, how can I help you?
Thank you, Madam Chair. Yeah, Attorney Markle. I mean, it's not on the same-sex issue. My question is, I'm married for 5 years. I've been drunk and a drug addict for 3. I'm in 6 months recovery. Could they go back and would that be grounds with this change of 2 years? Is it, I mean, does this assume consecutive years or current?
Well,
2 years?
Oh, okay. No, I'm sorry. Yeah. Well, it's basically 2 years. If I read this correctly, I think we have 2 years together. Oh, 2 or more years. Okay, I see. No, I just had to double check what was written here. It's 2 or more years. It could be separate, or it could be departed. That is left to the discretion of the court, and that's going to be able to reduce problems with offers of proof. So in your case, the issue, I think, is whether or not you're trying to rehabilitate yourself and you're falling back in there. So that's going to be up to a court to decide. If I haven't answered your question, please let me know.
No, you have. So it's not community.
You have a follow-up?
I do. Thank you. Yeah, thank you, Madam Chair. I do.
Follow-up. Go ahead.
So it's not current and in a row.
That's correct.
So my follow-up is, I mean, who verifies this? What happens if both parties are having a drinking problem?
Well, then you have, yeah, okay, those are good questions. Then what you have is the affirmative defense of recrimination. Let me explain. You have to, it's important to remember that to be able to prevail in a fault-based divorce, the other party has to be blameless of any conduct that would have taken place, which also would have given rise to a fault-based divorce. So in other words, when you read RSA 458(7) and you're looking at fault-based divorce, it basically says a divorce shall be granted on these grounds to a party, for want of a better term, who was blameless. It's innocent party is the way I think it reads. And that means you haven't done anything wrong. So in other words, if we go to court and I say, you've been abusing alcohol or drugs for the last two of the last 3 years, and you say, but judge, she has been doing exactly the same thing, and you bring the evidence in, well, that kind of cancels it out. That's in the law. That's an affirmative defense of recrimination. Okay, that's what it's called. So you can't prevail on a fault ground that way. Now, the reason it says 2 or more years, I think you can fairly infer, is that people can have problems in a marriage. People can go through rehabilitation in a marriage, but if it looks like the effort has failed, and this does not allow a divorce on one night of drinking or, one night of drinking or even a problem with drinking for a short period of time, this is going to be at the discretion of the court, as these cases often are. Did they prove their case is the question. So that's where I think you're kind of at with this. If I haven't answered anybody's question, please continue to ask me. I'll make sure I can get it.
Mr. Markel, will you take another question?
Sure.
Thank you. Representative Grossman, can you unmute?
Thank you, Madam Chair, for taking my question. So I too have concerns regarding the alcohol drug abuse section.
Okay.
What happens if someone, so recovery and sobriety are a very fluid situation. What happens if someone is actively trying to get sober, relapses, where does that fall in here?
Okay, very good question. And that's really going to be a matter for a court to decide, because that's going to be fact specific. What we're talking about here is having the grounds to plead. Basically, this is somebody who's going to be able to say, Your Honor, this has been the problem in the marriage. This is what I think caused the breakdown of the marriage. And then you plead your case, okay, and then the court has to decide. So in other words, and I have these cases where somebody comes in, and I have them where somebody's been an alcoholic. Right now, as it stands, you can't plead a drug problem because we don't recognize that under the law in New Hampshire. And I've had those cases. Right now, to be more specific, I have 2 of these cases right now, just like this, okay? Somebody goes into rehab, somebody comes out, they continue drinking again. So in other words, that's going to be part of the cause of action that you plead. It's going to be, but judge, he, she went into rehabilitation, they tried to clean themselves up, but it didn't work. They're back to drinking again. You know, over the last 2 years, he, she did this, went into rehab, came out, went back to drinking or taking drugs again, went into rehab, went back in, and repeats a cycle as often, and particularly with drugs, which takes place very commonly. I've seen those cases too. So that's the issue for a court to decide. That's fact specific. 2 years, I think, is enough of an opportunity to be able to say, you know, the marriage is damaged beyond repair, and this is the problem that we see in the marriage. So we've tried, we've lived with it for a while, this kind of thing. That's how I see it. I think it improves the statute, particularly with adding the drugs aspect to it, because that's really commonplace today.
Thank you, Mr. Markel. Will you take another question?
Yes, I will.
Thank you. Representative Altschuler, you may ask your question.
Thank you, Madam Chair, and thank you, Mr. Markel, for taking my question. You mentioned that you have 2 cases ongoing right now.
Yes.
In your experience, how many divorces are found on fault grounds?
Well, that's fact specific. We plead them. I can't give you a definitive answer other than to say cases plead, okay, which is the important thing. How they resolve is something different. So to directly answer your question, do we plead fault grounds? Yes, we plead fault grounds when A, the client thinks it's important, and B, if it looks like there's a chance of prevailing. But given the fact that I would say better than 90% of the cases that are filed resolve, people may look at the fault grounds and say, well, in the interest of settling the case and getting other aspects that I want, I will dismiss on fault grounds. And they will just go for irreconcilable differences. But it's very common practice to affirmatively plead fault grounds in a petition or cross petition for divorce, in addition to irreconcilable differences, if you have them. One of the less pled grounds, interestingly enough, which doesn't figure in here, is impotence. I actually have a case right now where impotence is one of the fault grounds that's being pled.
Thank you, Mr. Markel. Representative Altschuler, do you have a follow-up?
No, I'm good, thank you. I will lower my hand.
Thank you. Any other questions? Seeing none, I will close the hearing on House Bill 142 and ask Mr. Markel to stay on the line. So once I introduce House Bill 547, we can hear from Mr. Markel, and then we have other people to testify. So stay tuned.
Madam Chair, Representative Petrino here.
Yes, Representative.
I would just like to acknowledge my presence. I apologize for being tardy. I'm in my home office alone.
Thank you, Representative. I also see Representative Smith.
Yes, I'm sorry. I had my date confused.
That's
I thought it
okay.
was 9:30. I am here with my 3 children and my husband and my loud dogs, but hopefully you won't hear any of them because my earphones are in.
That's okay. Welcome.
Thank you.
And Representative Alicea, did you record Representative Belanger as being present?
Did he just come in?
Yes.
Okay, yes.
No, ma'am. I've been present since 9:12.
Yeah.
Excuse
Did
me, 9:16. I apologize.
Representative Petrino just signed in.
Right.
Okay, you can correct me if I'm wrong, Vice Chair DeSimone. It's my understanding that until they're physically at the meeting, that's the time that I need to put down. So initially I had 9:20 for Representative Belanger, but it's now 9:37. So
Yep. I just wanted to be sure you had him. So 9:20, 9:12, those are perfect.
Okay,
For Representative Belanger.
Thank you.
Thank you.
Madam Chair?
Yes. Yes.
May I please read out after each of the bills, how many people have signed in and
I apologize. You're
No
correct.
worries.
Thank you for bringing it to my attention.
I just want to make sure before we move on to the next one, so it doesn't get confusing.
No, you're absolutely correct. I'll read those out for you.
Great.
I have the House testimony sheet for House Bill 142. We have 8 in support and we had 2 testify. We had 0 opposed and 0 neutral. Thank you for bringing that to my attention, Representative. I'm new at this.
No worries, me too. A quick question for you. You had just said 8 in support,
Yes, ma'am.
and I have a sheet here that says 10 in support. So is it possible that 2 more people signed in or they took their names off?
It's possible that 2 more signed in since this sheet was printed. So that's good. We have
Answer that
10
for
in
you,
support.
Chairwoman DeSimone. I did print those sheets for Representative Altschuler after you were given yours, so it is possible. So hers are a little more recent.
Thank you, Christina. You're awesome. Okay, thank you. Anything else, Representative Altschuler?
No worries. Because I also had 1 testify, but we ended up having 2. So,
Correct.
Right.
Correct.
Just make a note. All right, so we'll confer. Thank you so much.
Thank you.
Yeah.
Okay, so we have closed the hearing on House Bill 142. We will now begin hearing testimony on House Bill 547, and I will open the discussion. I'm sorry, is Representative Gay here? Yes, she is. Representative Gay, if you can unmute.
Yes, I have.
There you go. Would you like to open House Bill 547?
Yes, and I commend all of y'all for dealing with such a difficult subject all day long, all year, both years long. Now that I'm on Health and Human Services, we have similar concerns. House Bill 547 is extremely simple, and if you had told me this 3 years ago, I wouldn't have believed that it was necessary. But since then, I have learned that some judges, and when I say judges, I don't mean all, I mean the ones who are doing this, okay? I don't, by my telling you that things need to be improved, I do not intend it to mean criticism of everybody in that category. But the serious situation is that at least some judges are breaking rules and ignoring RSAs. And this one in particular was that no evidentiary hearing was ever permitted to this parent who had serious concerns, had documentation of abuse of her child by her soon-to-be ex-spouse was never permitted to have the hearing because the judge, I can't say why, but I do know that she had been ordered to take her child to a supervised visitation with this soon-to-be ex-spouse. And there was the person who was supposed to supervise it had just been stripped of her credentials for cause. And if that wasn't bad enough, the place that they were supposed to meet had none of the protections that are federal and state for making it a safe place. There's quite a list of federal and state requirements for safety. Unfortunately, that's probably another bill that I think y'all have attempted to get it passed for safe, I can't remember the real term, but it's where, children can meet with a spouse, a parent. So she said, I can't bring my child there. It's dangerous. And all I can think is that was the reason that the judge refused to give her an evidentiary hearing, and instead, ultimately, without ever hearing for her, gave custody of her daughter to this abusive parent that she had no chance to show how dangerous he was. She had to give up everything and leave the state with not much more than the clothes on her back. So I don't know how many other people have been treated like this, but I've had 2 people suggest that it should be amended to say that this says, that, excuse me, in any proceeding to determine parental rights and responsibilities, each parent is entitled to at least 1 hearing to present evidence and call witnesses. So 2 people have said, one is they ought to say they have equal number of testimonies because often the person who has more money can ask for more hearings and pay for more. And the other person, an attorney, said, and no unsupervised visitation until evidentiary hearing is held for both parents. So that concludes my testimony. I certainly hope that you can help elaborate on the finer points of the law.
Thank you, Representative Gay. Do we have any questions for Representative Gay?
Representative Vice Chair, does Representative Gay have a written testimony, please?
Do you have written testimony, Representative?
I have emailed y'all, and if it may make it easier, I'll just email again.
Thank you. Can you specifically email it to Representative Alicea?
Yes.
Thank you.
Thank you kindly.
Okay.
The next person that we have to testify is Erin Justina. Miss Justina, thank you.
Good morning, Madam Vice Chair and members of the committee. My name is Erin Justina, and I direct the Domestic Violence Advocacy Project at New Hampshire Legal Assistance. For more than 20 years, the Domestic Project has been representing victims and survivors of domestic violence, sexual assault, and stalking in their protective order cases, as well as their high lethality divorce and parenting cases. I'm here today to testify in opposition to House Bill 547. I'd like to begin by mentioning that a similar bill was proposed by Representative Gay last session. That was House Bill 1270. That bill was ITL'd by this committee in a unanimous 19-0 vote. House Bill 547 seeks to correct a right which is already afforded to every litigant entering the family court system, namely the right to seek justice. This bill seeks to add a new paragraph 4 under RSA 461A3. But if you look at the existing statute, namely paragraph 2, which reads, in cases where husband and wife or unwed parents are living apart, the court, upon petition of either party, may make such order as to parental rights and responsibilities in support of the children as justice may require. So upon petition of either party means that one of the parents makes a request to the court to be heard on a particular issue. So once that happens, the law goes on to say that the court may make such order as to parental rights and responsibilities. In order for the court to make an order, a hearing must be held. So to add a fourth paragraph would be redundant and is unnecessary. Additionally, the language of this bill will cause confusion as it states each parent is entitled to at least one hearing. So does that mean one hearing per parent? Do the hearings happen simultaneously where the opposing party has an opportunity to question the other party's witnesses and review evidence? Or will the court need to schedule a separate hearing to allow the other parent to respond? This bill is likely to lead to confusion and is redundant of a right already afforded to family court litigants under the law. Therefore, I respectfully request this committee vote inexpedient to legislate. Thank you.
Thank you, Ms. Jacina. Do you have written testimony that you have submitted or will submit?
I have not submitted written testimony. If the committee would like to, I can summarize the testimony I just gave.
Thank you. We would appreciate it if you could email it to Representative Alizea to be entered into the record.
Absolutely.
I do see that we have two questions.
I'm happy to answer.
Thank you. We have actually three questions. Representative Long, can you unmute yourself and ask your question?
I can. Thank you, Madam Chair. So, Aaron, the bill, so what you're claiming is the bill is redundant when you, because it's allowed in 461-A:3(2). Correct? And that's what it looks like that I'm reading here.
Correct, yes.
Okay, do you know, since we're on these divorces, do you feel that if we're going to change, you know, if we're going to accept bills or change bills or propose bills, that in cases where husband and wife language is there, should we use that, you know, use this opportunity to fix that, or is that being taken care of in the Supreme Court?
You mean in the difference between a divorce case and then just a straight parenting case?
Well, from a same-sex married parent, both of us are parents to a child.
Yeah.
It doesn't apply because we're not husband and wife.
So, right. So this is just in the parenting statute. So if it was if there was a divorce case with kids, this would apply as well.
Okay, great.
Yeah.
Okay, thanks.
Thank you, Representative. The next question is from Representative Altschuler.
Thank you, Madam Chair, and thank you, Ms. Jacina, for taking my question. If I understood your testimony correctly, is it your assertion that this is a due process issue that's already addressed in the same statute?
Yes, thank you for your question. So just to be clear, at any point in the process of filing a parenting petition or a divorce petition, there's already a system in place for litigants to seek relief at any point in the process. There are multiple hearing phases along the way, and there's nothing preventing someone from accessing the court system to get justice. So the due process issue is already addressed in paragraph 2.
Okay, thank you for the clarification.
Thank you for your question.
Thank you, Ms. Messina. We have one more question. Representative Yokela, can you unmute yourself?
Yes, thank you. I had a question about your statement that there was required to be a hearing based on the request of either party, but it seemed to me by the language that you read that they could request, they could say that there is an issue, but that doesn't necessarily mean that the court will grant a hearing to, have those people submit evidence and testimony, et cetera, to that fact. Could the judge not just decide on the petition alone and not have a hearing? Is that not the case?
Thank you for your question. So a party would either petition the court through a parenting petition or a divorce petition, or if the case is already opened, they could file a motion requesting any kind of particular relief. It is possible that a judge would issue an order based on the pleadings alone. It's less likely in my experience, but even in that situation, even if the party filed a motion and didn't agree with the judge's decision, there is an appeals process. You can request a hearing. You can request a motion for reconsideration. There are multiple steps along the way that would allow for a hearing for a party to be able to present their evidence and present witnesses. And even at that point, even after a hearing, if somebody doesn't like the decision, you can appeal all the way to the Supreme Court. So there is a process in place to be heard. So for those reasons, and as well as the language in existing statute, this bill really is not necessary. I can't speak to the particular facts of the case that Representative Gay presented, but I can say in my experience that these cases tend to drag on quite long in family court because parties are always getting hearings. Anyone can request one at any time, and it may not be scheduled in a timely manner, but one will be scheduled and the parties will be heard.
Do you have a follow-up, Representative Yokela?
Yes, thank you. You said that there was an ability to appeal and to question essentially the ruling. And do those appeals, is it an option for the judge to allow?
So it's really, I would say it's more a litigant's option. This system is in place for the public to. So I'll give an example. You have a temporary hearing and the parties have a temporary hearing. And at the end of the temporary hearing, the judge decides that both parties should be able to spend time with the kiddo despite there being evidence of abuse. So the victim in that case, obviously being concerned for the safety of the kiddos and the safety of herself, disagrees with the judge's decision. Maybe she presented evidence, maybe the judge misconstrued the law, at which point she can file a motion for reconsideration and saying all of the reasons why she disagrees and why the judge got it wrong. If the judge does not agree, at that point, there are further levels of appeal, including going up to the New Hampshire Supreme Court.
Another follow-up?
Sure, one more.
Thank you. So what you're saying is that you can request an appeal, but it doesn't necessarily need to be granted, or a hearing doesn't need to be scheduled for any of those appeals. They could all just be denied without a hearing, is what you're saying, if I'm understanding correctly.
So that's not exactly right. So if somebody files a motion to reconsider a judge's order, you are correct. A judge could say that there's not going to be a hearing on that issue. I'm denying your motion for reconsideration, at which point you have further appeal options. And likely at that point, there would be some kind of hearing held. But that's a little bit different than what this law is stating or what this bill is requesting, that anyone can request a hearing at any time, that is already in place. So it's confusing because it's really two separate issues, whether you're appealing an issue or whether you're requesting relief for a particular legal issue or you're seeking a particular legal outcome. In which case, that's how the family court is designed, to allow litigants to do that and to have the opportunity to be heard.
Thank you.
Thank you for your questions.
Thank you very much, Ms. Messina. Mr. Markel, we have about 3 minutes before our next bill. Do you have any input?
Okay, thank you. Thank you, Madam Vice Chair. The situation here, as I see it, is whether or not you have a right in family court, as you do in virtually every court, at least in the state of New Hampshire, for notice and opportunity to be heard. What you have being heard is fully heard. That can mean a hearing, and that can mean a right to present evidence and witnesses. The questions are, and by the way, that's, I think, already enshrined in New Hampshire case law. I'm thinking of COSAC off the top of my head, but I could be wrong on the site. However, the question is whether or not this is self-executing. And whether this is self-executing is a decision the committee has to make. So if a person requests a hearing and it's denied, then I think you probably have a very good, you may have a very good denial of due process issue there under the 14th Amendment and under the New Hampshire Constitution as well. So that's something this committee is going to have to decide, I think. The other thing is, just speaking as a practical matter, appeals are very expensive, tedious, and time-consuming, and not everybody can do it either on a self-represented basis or certainly through an attorney. That's just my brief take on it. So it's a decision the committee makes.
Thank you, Mr. Markel. Representative Belanger, do you have a question? You can unmute.
Thank you, Madam Chair, and I appreciate it. My question is to the previous speaker, not Mr. Markel. If you can, so I myself am going through family court, and if I understand this correctly, the appeal process can be lengthy. So when you appeal, the motion to reconsider is denied. You can appeal to the next court, correct?
Yes, this is Erin Jacina. Yes, that is correct.
Follow up, Madam Chair.
Certainly, one follow-up.
So if I can appeal that decision, what do you have a percentage of cases? Is there data that supports how many cases are denied upon that appeal? And is there, in family court, is there a requirement that there is always at least one hearing?
So there's always going to be one hearing. I'll address your second question first. There's always going to be one hearing in family court if the parties, at least one hearing, because that's just the nature of how family court is designed. Assuming the parties don't wish to settle the case and want to proceed on a litigation track. There's going to be first appearance, and then there may be a case manager conference. And then if the case is not settling, you're going to a temporary hearing. You're going to get that temporary hearing. And then if the case is not settled at that point, then you're going to have a pretrial conference. And then after that, you're going to have a final hearing. That's the general track that litigated and contested cases take in family. That's the basic track. So in addition to that, at any point, someone could request a review hearing, every 3 months, every 6 months, if the case is going on and on. But everybody is going to get the temporary hearing, possibly the pretrial conference, and the final hearing.
Thank you, Madam Chair. No follow-up.
Thank you, Representative. Any further questions from any of the committee members? Thank you. I will read the remote testify sheet. We have 21 in support. We have 1 in opposition, 0 neutral, and we had 3 people testify. And with that, I will close the hearing on House Bill 547.
Oh, Madam Chair. Yeah, this is
Yes,
Representative Long.
Representative?
During this hearing, my video was turned off by the host. So I don't know, I probably didn't shave too close this morning, but I'm not sure why that happened.
Okay, Christina, did we shut Representative Long's handsome face off?
No, I didn't.
It says you cannot start your video because the host has stopped it.
Well, there you
The
go.
host is that, okay, very good. Thank
Sorry
you.
about that. I'm not sure what happened.
There you are. Welcome back. Thank you, Representative Long, for bringing that to our attention. And with that, we will open a hearing on House Bill 139. And I will ask Representative Yokella to unmute himself and introduce his bill.
Thank you, Madam Chair and members of the committee. I am here today to introduce HB 139 relative to submission of evidence in divorce proceedings. This bill has come back again. It was originally, I think, introduced back in 2018 or something like that and passed this committee and got changed in the Senate and in the Committee of Conference, died. And then last year there was some minor alterations and ended up not passing. So I have submitted again today, and the main gist of the bill is to allow for at least 5 days of that evidence being submitted in divorce proceedings be submitted at least 5 days prior to the hearing, so that people have an opportunity to gather evidence to support their defense, so that they are not ambushed at the last second with, you know, hundreds of pages of evidence that they are intended to on the fly address in the hearing. And the amendment last time was to allow for, in addition to de minimis evidence, also to allow an exception to a requested continuance if such evidence was not available to the party submitting the evidence 5 days prior to the hearing. So that should address any issues like any activities or evidence of activities that happened during that 5 days prior, or it wasn't just available for any other reasons. Let's say, you know, you didn't get it in the mail from, you know, the IRS or whatever until the day before the hearing, and you want to submit that. And so what the point of this bill is to allow for an automatic continuance if you didn't get that evidence in that 5-day window, so that you have an opportunity to look over it. And if the court denies that they write down why they're denying it, so that you have the reasons that you can appeal based on. So I hope you will support this, and I'm happy to take any questions.
Do we have any questions? Representative Altschiller, you can unmute yourself.
Thank you, Madam Chair, and thank you, Representative Yokela, for taking my question. You just mentioned in your testimony that the inspiration for doing this, if I understand you, was to make sure that everyone gets all of the information they need ahead of time before a hearing so that they aren't ambushed, I think you said, with information. But right now, I believe the time frame is 10 days. This bill would shorten it to 5 days. But there's nothing here that stops somebody who doesn't abide by any deadline, 10 days, 12 days, 5 days. It doesn't stop them, and there's no penalty for showing up to court on your court date with a stack of documents yay high, and then force the other party into making a decision as to whether to continue because they have waited for months and months and months for a hearing, or continue in the moment, or wait yet another 90 days for some relief. And it seems that this would really negatively impact victims who are, who are low income members of our community, because it puts them between a rock and a hard place anyway. And I feel like in cases of alimony and child support, that this is an opportunity, it's a wedge for abusers to be able to manipulate that system.
Do you have a question, Representative Altschiller?
So my question is, was this part, did you consider this when you wrote this, and did you have an intention or an amendment forthcoming that would address that issue?
Thank you for the question. So as you stated, there is currently court rules that require them to submit it even prior to the 5 days. So if the problem is that, exactly as you stated, that if people don't abide by that, currently there is no punishment necessarily given by the judge. It's definitely within their prerogative because they're, not abiding by court rules, but it doesn't necessarily give any. There's definitely no punishment automatic in that case, and it's potentially possible that the judge could waive that rule and not put any requirement or grant any recess and insist that the hearing go on at that point. And so I think that this bill actually says, okay, if you've broke the rule so much that you're all the way down to 5 days and you're giving that testimony or that submitting that evidence at that time, I want to give the person that is being essentially ambushed, the opportunity that they're not currently given necessarily by the court to continue. So I think that bill is actually increasing the opportunity and increasing the rights for the person being ambushed and not reducing their rights. I think it's putting, that kind of a stopgap in between and saying, okay, the judge can waive it. If it was 6 days, they can waive their court rules. But if it's 4 days, they really need to give the option to the person to continue the hearing if they need time to prepare their defense. And so I think this is actually helping, not limiting it even further. But thank you for the question.
Thank you, Representative Altshuler. We have one more question. Representative Belanger.
Thank you, Madam Chair, and thank you, Representative Yokela, for bringing this forward. I'm not sure if you're familiar with the court process, but when filing an initial motion for any court proceeding, is there a wait time or an expected response requirement before the court can move forward with making a motion? Excuse me, making a decision on that motion.
I'm not sure that I am the best person to answer that question. No.
Okay, follow up, Madam Chair.
Follow up.
So, and I do have a question here, so I apologize, and I will keep this part brief. But yes, there is, when you file an initial motion, there is a respective 10 days that the other party before a court may make a decision on the original motion, the other party has at least 10 days before the court can make that decision. So if I understand your bill correctly, that is essentially what this is doing when submitting evidence into court, giving them a 5 or 10-day grace period for responding to the evidence presented to the court.
Thank you for the question. I'm not sure that that was a question, but I will address it anyways. Thank you. I think that, so this is only for, not necessarily for motions. This is for in preparation for a hearing. And so it's possible that you could submit a motion, outside of a hearing, but prior to a hearing.
Sorry, clarification.
Sure.
Okay, sorry. So yes, it was a question. I was asking if your bill pertaining to hearings is essentially the same, is what you're trying to accomplish with the 10-day grace period with motions.
Thank you for the clarification. So there are rules that say that you're supposed to have, just like in the 10 days to respond to a motion, you're supposed to submit your evidence 10 days prior to the hearing that you're going to be submitting to the hearing, but that is not always followed, and the judge doesn't always give the opportunity for the respondent to be able to adequately prepare to address that evidence. And so this is providing the opportunity for that person to have some relief and say, I need time to prepare. There's a lot of evidence that I am not, that I haven't had time to prepare. And let's say I'm a pro se litigant. And so I need as much time as I can, but the court is required to have that continuance within the 90 days. And so it's not going to be pushed out at least 90 days. It has to be happening within 90 days. So I don't think that it's going to push the hearing out super far. It will just give it's kind of a balance between, originally it was, the continuance would be not more than 30 days, but the court requested that it be 90 days so that they have time to schedule it. And so, and not be bogged down. So I don't think that is going to, I don't think that it is exactly what you're asking, but I think it's just it's meant to give a stopgap and say this person needs this right to prepare for their hearing. But thank you for the question.
Thank you for answering the question. No more follow-up, Madam Chair.
Thank you. We have one more question. Will you be willing to take that question?
Absolutely.
Representative Long, go ahead.
Thank you, Madam Chair. With respect to the court basis for its, documented the basis for its finding, could that basis be de minimis nature?
Thank you. Yes, I think that is, so yes, it could be de minimis and say, this is the reason why, and then you would be able to appeal and say, hey, it's not de minimis for the XYZ reasons, and therefore have a motion for be able to, logically argue why the continuance should have been granted, and that they have been, this is a miscarriage of justice, essentially. The main reason for having it written is so that you have something to base your appeal on. But thank you.
Okay, so I'll follow up if I may, Madam Chair.
Certainly.
So the document can just read de minimis in nature, and that's the judge's document for the basis of his finding. Then that's added, this bill is okay with that. Okay, great, thank you.
Thank you. We now have Erin Jacina to testify. Can you unmute yourself, please, Ms. Jacina?
Yes, thank you, Madam Vice Chair. So again, my name is Erin Jacina, and I direct the Domestic Violence Advocacy Project at New Hampshire Legal Assistance. And I'm here today to testify in opposition to House Bill 147. As Representative Yokela mentioned, there was an identical or near identical bill proposed last session that was House Bill 1103, and this committee voted to ITL that bill. So while this bill is well intended and seeks to level the playing field for litigants, there would be unintended consequences, as Representative Altschuler mentioned. So if you're thinking about two parties that are scheduled for, let's say, a temporary hearing, and one party is a victim of domestic violence, the other party is her abuser, he reads this law and says, okay, well, I know how I'm going to continue abusing her through the court system. Can't do it in person anymore, so I'm going to abuse her through the court system. So I've been holding on to this stack of financial records, and I'm going to show up to the hearing and I'm unrepresented. So the court is really going to give me some extra leeway, but I'm going to show up for this hearing with my stack of financial documents because I know she's seeking alimony and child support. So she's not going to have time to review any of these records. So as Representative Altschuler said, you're really stuck between a rock and a hard place at that point, because the victim shows up to court, most likely also unrepresented, and is just given this stack of financial records. And you're not going to be able to go through those and digest those records 5 minutes before a hearing. You're certainly not going to be able to run a child support calculation or figure out what a temporary alimony award should be. So then you're faced with the fact of, okay, well, I could just go with what I prepared and ignore what was just handed to me or take his word for it, or I can request a continuance, which is likely going to be granted if this bill were to become law. And now we're looking at a period of not more than 90 days. So even if you go out the 3 months, that means for those 3 months, that victim is potentially without child support. That victim is potentially without alimony. So she's not able to pay her rent. She may not be able to pay for her car. She's not able to take care of her kids. And this is all intentional from the abuser. And I do also want to point out that because we're in COVID-19 right now, we're dealing with COVID-19, the court has issued emergency orders, which allows them to extend certain deadlines. So right now we're talking about 90 days, but for however long these emergency court orders in effect, that 90 days could be out the window, and we don't know how long that will be. So she may not get a hearing now for 6 months, and that's far too long for a low-income person or any person to have to go without some sort of financial relief. So that's my concern with the 90 days. But then there are other practical considerations related to this bill. This bill is seeking to set evidence requirements in the divorce statute, but it is not addressing evidence requirements under 461A, which is the parental rights and responsibility statute. It doesn't address what happens in those emergency type cases where someone files an ex parte motion. The court has to have a hearing on those cases within 30 days, but the respondent has a right to request a hearing within 5 days. So a hearing could be scheduled within 2 days. So how does this bill interact with those requirements that are already in place? It also would trump a number of family court rules, which are already in place related to submission of evidence prior to hearings. So for those reasons, I respectfully request this committee vote inexpedient to legislate, and I'm happy to take any questions. Thank you.
Madam
Thank you.
Chair.
Representative Alicea, do you have a question? Please unmute yourself.
Okay, can you hear me now?
Yes,
Okay,
ma'am, go ahead.
It's not a question, it's just a statement for the record. The last speaker, Aaron Justina, at the very beginning of the testimony for 139, she stated 547, but she did speak on, but this one was 139. So I just wanted to clear it.
Thank you. I apologize for that.
It's okay. Thank you.
Representative Wazir, did you have a question? Thank you. Does anybody else have any questions? Seeing none.
Madam Chair.
Representative DeSimone, my apologies. You do have several people with their hands raised in the attendees.
Right, right.
One that had written in to request to testify, if you wouldn't mind.
Right, that's what I was going to do next.
Thank you.
But I do see that another representative raised his hand, but he took it down. Okay, so in the attendees list, I see Paula Warma. Paula Warma, can you unmute yourself? Did you want to testify? Ms. Warma, could you please unmute? We'll go on to the next person and come back to Ms. Warma. We have a Katz Cruzan. Would you like to testify? Please unmute.
Can you hear me?
Yes, we can. Do you want to testify?
I sure do. My name is Alice Giordano, and I am appalled at some of the things that I heard earlier. I have been raising my hand since the beginning of 139. The gross misrepresentation that I've heard and what's really going on in the family courts right now is baffling. I know that you've passed 139, so I'll be brief. I do not have any formal statement. I just actually learned of these bills this morning. In terms of evidentiary hearings, there was a speaker. He's absolutely right. That is the most fundamental due process right afforded to every American citizen in the United States in a court of law. Unfortunately, in the state of New Hampshire, the family court judges have decided on their own that that due process right is an option. And if you want to take what's on paper and what's really going on in the courts, the difference is mind-blowing. It should shock the conscience. You have family court judges that are denying multiple requests, people begging for evidentiary hearings, and the courts are waving their magic wand, their judiciary magic wand, in a court system that is so unchecked and unbridled that there are crimes, literal crimes, and I'm not a crackpot. I have a background. I was a reporter for the national press. My child actually attended school with Erin Jazina. She knows what's going on in the courts. She certainly knows that there's problems with due process. In my case, I had 4 separate motions for an evidentiary hearing denied. You can look at my case. The judge even quoted himself. I'm not interested in hearing any evidence. You'll be hearing later in the day about what they're really interested in. What they're really interested in this is this thing called reunification therapy that is lining the pockets.
Excuse me.
Of all the appointees. I'm almost done.
Excuse me, we're hearing testimony on House Bill 139. If you want to talk about reunification, you're going to have to wait until that bill comes before us. So do you have any further comments on House Bill 139?
Yes, I do.
Thank you. I'll give you another minute or so.
Thank you. This bill is critical to pass because the problem is if it's not explicit, then the judges aren't going to do it. And sadly, in the state of New Hampshire, you're going to start needing to spell out every little right in writing. And by the way, this idea that you can appeal is just nonsense. The only appeal process in the state of New Hampshire, unlike other states, is in fact the New Hampshire State Supreme Court. So the only bite of the apple that families have at getting evidence into the court system is in fact through the due process of the right to submit evidence, which is being denied repeatedly and grossly. It's rampant. It's a rampant problem. There are cases. I know of a case where the woman showed up with all her expert witnesses, and the judge wouldn't even let them in. They are grossly denying due process. I urge this committee to look further into this matter. I'm an open book. I know many parents who will share their records with you to show. We even have it in writing that these judges are denying our right, our most fundamental right. Could you imagine being accused of murder and you go to trial and the judge says, I don't want to hear any evidence. I'm just going to make up my own mind. And that's exactly what's happening in the court system in the state of New Hampshire. Thank you so much for listening to me.
Thank you, ma'am. Do you have written testimony that you can submit to the committee?
I sure do.
Thank you. Would you please email that to Representative Caroletta Alicea?
I'd be happy to.
Thank you kindly. Have a great day.
You too.
Do we have any questions? Seeing none, I'll ask Paula Warmay to unmute, please.
Susan Nahata.
Paula, are you there? Okay, I'll ask Mr. Markell if he would like to testify.
Thank you, Madam Chair. Yeah, the situation, what you really have here is I think you're talking about abusive discovery practices. And I would agree with a prior witness that they unfortunately can be rampant, but I'm not sure that this bill is the way to do it. Let me explain. When you're talking about things like submission of exhibits and courts typically issue scheduling orders. Scheduling orders are the timing and sequence of discovery.
Hello?
Yes.
Hi, can you hold on for a moment? We have somebody else.
Is anybody there?
Hello, can you hear me?
Hello?
Go ahead, Mr. Markell.
Thank you. Typically, you have what are called scheduling. Typically, when you have temporary hearings, typically courts will do what they're called is jointly temporary hearings and scheduling conference hearings. And this is typically where courts listen to the parties, try to determine what the issues are in the case. Then issue discovery deadlines, and then also issue usually timing and sequence of exhibits and things like that. typically they're adhered to. What this bill, I think, is well-intentioned, but it tries to micromanage a court's docket. And courts typically are able to
Hello?
manage their own dockets. So what you have here is, and the other thing is
Excuse
that
me.
here,
Excuse me, Mr.
Hello?
Markel. I just want to talk to Ms. Wormy.
okay.
Ms. Wormy, can you hear me? Can you hear me? She's obviously having technical difficulties. I'm going to mute her again and you can go ahead, Mr. Markel.
Thank you, madam. So what typically happens is this, and I think what this bill is well-intentioned, but what I'm hearing here is that the committee is probably maybe asking itself, what is the trial process like? And this is an attempt to manage the trial scheduling process, which is typically, when it's done correctly, is done by the court itself. It manages the case from beginning to end. So back to the scheduling conference order. You can typically find them online on the judicial website, and you fill them in and you submit them to the court, or the court administers its own. So when you look at, you'll also find the courts will include timing and sequence of discovery, and the court frequently will issue an order for the timing and exchange of exhibits. So the parties are to exchange an exhibit by a certain date, number one. And if they don't, and if somebody tries to play fast and loose with the timing and sequence and exchange of exhibits and the filing of exhibits with the court, the remedy can be frequently a motion in limine, which means that's a gatekeeping motion, which says, Judge, due to certain prejudice that I'm seeing, this person submitted these exhibits late, and now I'm prejudiced in my ability to present my case because they were late, because they were the result of issues that were either not discussed or previously discussed or not exchanged timely. My prejudice is thus and such and such and such and such. So then the court looks at it, and the court decides on the motion whether or not there's prejudice to the other party's case. So in other words, you could actually be within, assuming the bill, within that 5 days, but if there's no prejudice to the person's case, then it really shouldn't matter. And this is typically the way the New Hampshire Supreme Court is going to look at it. Since courts generally are managing their own trial dockets, when you go up on appeal with submission of evidence, then the court on appeal is going to look at whether or not it constituted an unsustainable exercise of discretion. And within that unsustainable exercise of discretion, the New Hampshire Supreme Court would look at it and say, okay, was there an objective basis in fact or law for the ruling below, which said, well, okay, the court decided this and decided this, and there was a basis for it. That being the case, the ruling would be affirmed. And when you're dealing with the unsustainable exercise of discretion, by way of further submitting this to you, the question is whether or not you had any prejudice to your case. So if somebody walks in with a stack of documents that I heard mentioned, the morning of trial, well, Your Honor, just going through this, I'm looking at this and I'm prejudiced. And if you have a good judge and this stuff is all relevant, then the judge is going to say, that's not coming in. Okay. I'm going to, and remember, motions can be made, written motions have a 10-day threshold as a general rule, but courts can entertain oral motions made right on the spot. So what we're doing here is that we're looking to manage the court's docket. And manage the court's docket, and which has traditionally been an area of regulation for the court. I'd be happy to entertain and offer any experience I have to the committee, so the committee can further study this bill, or the committee can make a decision on it, because this is the kind of thing that I think requires somebody with some knowledge, trial, how the system is managed, judicial experience, case management, and so forth. So taken in isolation, I don't see where it helps, no matter how well, but I get how well intentioned it is, and I get the frustration in it. I certainly can see that. If there are any questions, I'm happy to answer.
Thank you, Mr. Markel. I currently do not see any questions, so we'll try to bring in Miss Murma again.
Okay, thank you.
Thank you.
Hi.
Miss Murma, are you there?
Yeah, can you hear me this time?
We can hear you. Would you like to testify on House Bill 139?
No, I didn't want to testify on 139. I wanted to testify on 547. And I'm also trying to sign up to speak on 556, 577, and 548, and the website is not giving me the option to sign up to testify.
I apologize. We have concluded 547. So if you have written testimony, would you please submit it to the committee? Specifically use the email address of Representative Caroletta Alicea, who is our committee clerk. Would you be amenable to do that?
Yes, I sent everything yesterday to the committee email address, but I will resubmit it to Representative Alicea.
Thank you kindly. Although you are not signed up, you said, I will keep you in mind when we get to the next few bills and call on you to testify. Is that okay with you?
That is fine.
Thank you kindly. I'm going to mute you right now, but we will get back to you. Thank you.
Thank you.
Next, I have a Richard Head. Richard, would you like to testify on House Bill 139?
I would. Thank you, Madam Chair. For the record, my name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. Before I testify, though, I do have a question regarding the registration, because I did register yesterday for the last bill, 547, this one, and the next three, and that appears not to have made it to your list. So
I'll keep you in mind as we get to those bills. Please stay tuned.
thank you. And I've had a couple issues with the registration where I've registered and it's not made the list, but thank you for that consideration. Again, my name is Richard Head, testifying on House Bill 139. We do have, and we're testifying for information, we do have some concerns though with this bill. It does create direct conflicts with existing court rules in the timing of evidence, evidentiary disclosure. As Attorney Markel had mentioned, there are currently rules that set up deadlines within the court process. Final pretrials are scheduled where witness and exhibit lists are to be exchanged. This bill would conflict with existing court rules. And in general, as you would have probably heard in other years, there are concerns with legislating court rules. We do have a rules committee in which two legislators sit, a senator and a representative. And really, if there are rule changes that legislators are interested in presenting, it's really through that rules committee that court rules are established. So things that set deadlines within the court system for exhibits, witnesses, things like that are really within the purview of the court rules process. But we do have some significant concerns relative to conflicts as to which would apply, a statute or a rule. And this would create some direct conflicts with existing rules. And as you also heard from a prior speaker, once you set a rule like this, it can be then used to manipulate the process. And we would have some concerns about that, where an exhibit or evidence may be delayed deliberately by a party in order to effect a delay in the proceeding. So with that, I'd be happy to answer any questions, and I appreciate your time today. Thank you.
Thank you. Representative Long, you have a question?
Thank you, Madam Chair. Thank you, Mr. Head. I mean, we're hearing testimony and we've heard testimony in other, you know, on other bills with respect to the judges not allowing. Do you have a percentage or an estimate as to how many of these requests are denied?
So not something that would be tracked specifically. As you can imagine, you know, these are very, very busy courts. So the evidence is being, you know, evidentiary admission are being asked all the time. You know, you get it within the context of the precise rules, or you get people who show up and for the first time at a final hearing are coming in with various pieces of evidence or witnesses that, you know, are not within the way the court had laid out the case. So those are, you know, those can be denied, they can be granted depending on the circumstances. A great deal of discretion is afforded because you really have to take into consideration the nature of the evidence, when it was produced, what is the schedule that all the parties are required to abide by that was set by the court. How often have there been violations of that? So the short answer to your question is we do not track individual evidentiary decisions on each case, just by sheer volume and the speed at which these decisions are being made. But if evidence is being presented within the structuring conference order, the final pretrial conference, presentation of witnesses and exhibits, and they're appropriately before the court, they're typically heard.
Follow up for me, Madam Chair.
Go ahead.
Thank you. Yeah, it would be very helpful to this committee because as you hear in testimony, it is never allowed. You know, we have people saying that they are never allowed. So it would help me in determining some of this. What it, you know, I got to weigh both sides. I got constituents coming to testify saying it never happens. And then I've got the judicial branch saying, well, yeah, you know, it happens sometimes, but I'm not sure how often. So it really would be helpful to try to get that balance. And I understand that it's short notice for you to have the answer today, but that would be nice to know that there are predominantly, motions being heard. So thank you.
And thank you for that. To the extent we can drill down, certainly, you know, we just simply don't have evidentiary decision tracking capacity. Our system just simply doesn't do that. I would significantly dispute the never happened. Certainly people are upset at times with decisions being made by courts and may extrapolate out from that their experience is the way the courts always act, which is not correct. We, you know, very, very much follow the rules, the procedures that are set out, and the orders that are issued in each case in terms of procedure, and those are followed. And evidence is being presented every day in family court. Witnesses are being heard every day in family court, and you know the normal practice and procedure applies. There are circumstances where somebody believes they're being treated unfairly when in fact, you know, the rules were not being followed. And, you know, it just happens sometimes. Those individual cases are not representative of all of the cases. They're really, each circumstance is very fact specific and very timing specific. In each one of those circumstances has to be taken into account by the judge.
Thank you, Mr. Head. Any further questions for Mr. Head? Representative Lewicki.
Madam Chair, this is more of a point of information, but Ms. Wormer sent us testimony on 547, and as part of that, she included the form, which includes the scheduling and a whole lot of other stuff, and I think that would be very informative to the committee.
Thank you very much. So it has come to my attention, obviously, that some of the people who are attendees that would like to testify on certain bills are not on my list for whatever reason. Their testimony and your testimony is very important to all of us. Please, if you choose to testify on a particular bill and I do not call your name, please raise your hand and I will call on you. We cannot make proper decisions on any bill without hearing all sides of the testimony. So I ask you to indulge me and please raise your hand if we're on a particular bill and you'd like to testify. You cannot ask questions again, but you can and are hopefully going to testify. And please always remember to submit written testimony for our records so we can go over it when we exec these bills. I want to thank you, and with that, I will close.
I have a question, Madam Chair, with respect to what you just said.
I'm sorry, Representative Long, go ahead.
Yeah, I mean, with respect to the rule, reading the COVID-19, if people aren't able to testify, then we would have to redo this. And my understanding is that there are people that were signed up to testify that didn't testify. So I don't know if I just want to make sure we're on the up and up. When the public's saying that they can't testify, you know, the emergency order says with respect to this remote that we would redo it. So I don't know if Ms. Dyer can just get that clarification for us. Thank you.
Christina, can you clarify that for us, please? I know she's on working on another committee as well. It was my mistake not to hear those because they're not on my list. For House Bill 139, I had only one person signed up to testify. On House Bill 547, I only had one person signed up to testify. On House Bill 142, I only had one person signed up to testify. I understand that people's names are in the attendees list, but I cannot, there's no way for me to discern what bill they want to testify on or not. I'm trying my best. And I do agree that their testimony is extremely important and they do have a right to testify, but they did not sign up prior to this morning is my issue. So as soon as I can get in touch with Christina, I will have her discuss that for you. Does that work for you, Representative Long?
Yeah, that's fine. It just seems like there's there's miscommunication. It's internal is what I'm saying. It's internal. So it's not that they can't get in to testify.
They can get in to testify. They
Okay,
just
so
have
we're
not
fine.
signed up.
Right.
So people out there need to know that they need to sign up in order to be on my list to testify. And I'll talk with Christina and have her discuss that with you after. Representative Yokella.
Yes. So normally at the end, after we do all of the people that signed up, the chair moves on to hear people that didn't sign up but are raising their hand. And I think that was the step that might have been missed in earlier ones, and that was the cause of the frustration. So as long as we're doing that going forward, I think the issue will be resolved.
Thank you. I stand corrected. Does anybody else have a comment? Thank you. In that case, we will move on to House Bill 556, State Ordered Counseling, and I'll ask Representative Betty Gay to unmute herself, and she can introduce her bill.
One moment, please.
Okay, thank you very much.
Are you ready yet?
Thank you, Madam Chairman, for dealing with the difficult situation. I very much appreciate your including the people who had who did not know how to sign up and then couldn't. So thank you very much for it.
Whoops. I'm sorry, Representative Gay, I accidentally muted you. Please go on.
Am I unmuted now?
Yes, you are.
Okay. Yes, I was thanking you. This 556 was passed last year, and it passed. It was the second bill we heard on the very last day we met in March, and so it never made it to the Senate. This is probably the most, I think all my bills will serve victims of domestic abuse. This is probably the most important one. It doesn't say reunification therapy because you could do the same therapy and call it something else. The important thing is that any kind of counseling that the state orders should be one that is legitimate, that has training, that has certification, that has a certified CPT. I'm trying to remember what CPT means, but all your medical procedures have a procedure name. So this bill, that's why it says, let's see. Child welfare services, I'm so sorry, I'm so nervous because this is so important to me. Nothing in this chapter and any other provision of law shall permit a state agency, including the state courts, or a public or private provider acting on behalf of a state agency to require individuals to participate in counseling that has no CPT medical code and thus is not a recognized form of mental health treatment nor eligible for insurance reimbursements. So the victims of abuse suffer in two ways. Number one, there's an RSA that says the state does not force you to be with your abuser, but this does. They'll order what they call reunification therapy, which sounds great until you find out it's part of this, not our beloved Gardner, but a Richard Gardner who in 1985 convinced an awful lot of people in court to adopt this really sick theory that has been totally debunked repeatedly by professional child psychologists. Children who are abused do not make up stories. Parents may try to get kids to say things, but if a genuine counselor can talk with that child, if they start describing well, sexual abuse is one of the most awful ones, and unfortunately, it really happens. And some people have a hard time accepting that parents can do something so awful to their children, but they do. And when children can account that, they didn't make it up. So that is very totally accepted among professional counselors, child psychologists. In not only our country, this sick theory that child abuse, that the parent who reports abuse is the cause, and therefore the children aren't believed, the parents asking for help with the courts are not believed, or they're blamed. This is the worst. They're blamed for the child having a bad relationship with the abusive parent. And sadly, this sick theory has spread to England and has spread to Australia. I have listened online, I've listened to professional discussions where some people are hoping that it's going away. Well, it hadn't gone away and it's alive and well here. I hope to gosh that it's not prevalent in the state of New Hampshire, but it certainly is prevalent in the courts that people that I have been trying to help have had to endure. Let's see. So they suffer both ways. One is that they're forced to be with the abuser, and the other horrible thing is they are stripped penniless because this is not a professional accepted form of counseling. Insurance doesn't cover it, but the women, mostly it's women, but we know there are cases of men being in abusive situations who are working desperately to protect their children. They are told, if you fight this, and if you don't participate and bring your child to this therapy, we're going to give custody of these children to the abuser. And that is part of the plan. That is in writing. And I will send you the link. So if you find, whatever time you find, you can see it on testimony, where one of the Richard Ducote is a famous attorney, not famous here, but in Pennsylvania and Louisiana. And he is famous for his writings about dealing with abuse in courts. And he got one of the followers to spill the beans in court. I shouldn't use such a cutesy term, but he really spelled it out because this Gardner guy really believed in sex with children. And then he derived this, and a whole lot of abusers loved his theories about, oh, it's always the protective parent's fault that this child doesn't want to be with the abusive parent. And it's because the parent who reported it obviously is a bad parent, then custody goes to the abuser. And sadly, that's happening here. And so they get hurt twice. Oh, some women I know, and so many of them are scared to death. I've sent you testimony, I can send it again. Five written testimonies that I gave out last year too. They can't even say their name because they've been threatened that if they do anything that makes the GAL or the therapist or the judge angry, they know what's going to happen to them. They're going to lose custody. So it's coercive, it's threatening. It's not like any counseling you've ever heard of. It sounds more like being in a North Korean prison camp in interrogation. It's that bad, but you can make up your own mind. The testimony is there. Women have said, and it was two women who said this to me. They said to the court, I can't afford this with no insurance coverage. It costs anywhere from $150 to $350 an hour. And it is common for them to be ordered 2 hours a week for months. So they've said, I can't afford this. And they were told, not on the record, they were told, your parents can. There's one woman who would, I'm sure she'd love to testify, and I'll make sure she sends you her testimony. Her parents have paid out over $500,000 because they are so afraid of letting their grandchildren be removed to their abusive other parent's home. I'll send you testimony because this could go on forever, but this is a cancer in our courts, which is what one of the women who is in the House of Lords of England called it. So I will take questions, and I know there are people who are wanting to testify from their personal experience. And thank you, Deborah, so much. Madam Chair.
You're welcome. You're welcome. Are there any questions? Representative Belanger.
Thank you, Madam Chair. Representative Gay, what percentage of services that these families are receiving don't have this CPT medical code that you're aware of?
None of them have a CPT code. It's all reunification therapy is what they're calling it right now, which is the official, it's the official terminology used across all these countries. Reunification therapy and parental alienation is what they accuse the protective parent of, because when the children say they don't want to be with the abusive parent, the protective parent who's tried to get help from the authorities is accused of.
Follow up, Madam Chair.
Follow up?
So Representative Gay, have you reached out to the Division of Youth and Family Services on how often that this is happening? Or
They
how-
are not, oh, I'm sorry.
Go ahead, no.
They are not aware of it because you see, the families that DCYF helps don't have money. This is very targeted. It's very obvious who is ordered. It's the families that they think have money. DCYF has never heard of this. Every counselor that, we have multiple counselors who are representatives, they've never heard of this because everybody is scared to death to talk about it. You will hear from one person who testified a couple of years ago and has already testified today. She had to leave the state and hide her child when her to-be ex was given custody. He doesn't even live in New Hampshire. He refused to come to the first two hearings, but they knew there was money there, so they kept letting him, giving him another hearing to go to. And she's the one who testified she was never granted an evidentiary hearing either.
Thank you. No more follow-up.
Thank you. Any further questions for Representative Gay? Seeing none, we will head on to Sarah Heidebrecht. Sarah, are you there? Did you find her?
Please tell them they have to unmute.
She just jumped to the, yeah, so give me 1 second. Sarah, you're allowed to speak now.
Okay, thank you. I submitted a written testimony yesterday in case I wasn't able to join this part of the meeting. This bill to me is incredibly important. I would echo everything that Representative Gay has stated. Feeling in fear of the retaliation that I could face for testifying and kind of calling out some of the misinformation and orders that are given by the court. My situation is a little different right now in that we've been court ordered to co-parenting therapy, which again, if you read my testimony, is not a supported form of therapy by the majority of mental health practitioners in New Hampshire. In the process of trying to find someone that conducts co-parenting therapy, I called 46 licensed mental health practitioners in New Hampshire. The majority of them do not conduct court-ordered therapy, and furthermore, they don't do court or co-parenting therapy. Many of them had no idea what I was talking about. And to kind of complicate matters, the few that I did find who provided that service, it wasn't a billable code, or they were very ambiguous about, well, it may or may not be covered by insurance. My child's pediatrician, who tried to help with the search to find someone to facilitate this court order, said, quote, "That said, putting it all together right now, after the recent search efforts, I think we're at an interesting place where what is needed is clarification from the court on what exactly the intent is with the term co-parenting therapy, keeping in mind what is and is not available as options within the counseling world and our area in particular," unquote. Complicating this whole matter for me is that our case does involve domestic violence, and doing therapy with my abuser is also not a supported form of, it's not recommended by our domestic violence agencies within the state. The GAL knows this on our case, yet he continued to recommend it, stating that, well, perhaps I can do it virtually instead. That's not the point, you know, of domestic violence or feeling a power and control differential. So, you know, this bill is important for one aspect of it, but I feel like continued education in domestic violence for all of our court professionals is incredibly needed. My own primary care physician also stated when I asked them for assistance in finding a therapist, said, quote, unfortunately, I don't have essentially any recommendations for a co-parenting therapist. I recently saw a thread about a similar situation in which the therapists were saying that this is challenging to navigate, and the importance of educating judges in these cases, end quote. So again, it kind of goes back to the judicial system, and as part of the court order in our case, the judge also, in my opinion, threatened me by saying that if the co-parenting therapist recommends a psychological evaluation just for me, then I was responsible for it, for paying it out of pocket, whether it was covered by medical insurance or not. And I took that as, you know, a slap across the face, because if the judge was so worried about my mental health, wouldn't he, you know, have removed my child from my care? That's not the case. But it kind of goes back to what Representative Gay was stating about, you know, targeting certain parents who may have some ability to pay for these services, and kind of locking them into, you know, what the court feels like they want the outcome to be, really narrowing my ability to put the facts on the table and just let the system see the facts, instead of kind of shuttling us through all of these different interventions that aren't medically proven. So I'm sure I've overstated or overtalked my time, but I appreciate you hearing my testimony. I hope you can read what I wrote as well. And I hope you'll support this bill. Thank you.
Thank you. Any questions for Ms. Heidelberg? Seeing none, we will next go to Erin Justina. Ms. Heidelberg, do you have a written testimony that you can or have submitted? No, she's gone. Ms. Justina.
Yes, am I unmuted?
Sorry, Sarah
Oh.
is unmuted now.
Okay.
Oh, sorry. I emailed it yesterday to the CFL email address.
Thank you.
So you probably have it. Yep. Thank you.
Ms. Justina, you're unmuted now.
Okay, thank you. Again, my name is Erin Justina, and I direct the Domestic Violence Advocacy Project at New Hampshire Legal Assistance, and I'm here to testify in opposition to House Bill 556. As Representative Gay mentioned, this bill was proposed last session. A similar bill was proposed last session. That was House Bill 1167. And that bill did die in chamber on June 16, 2020. So this bill seeks to stop reunification therapy, which I agree can be completely triggering and further traumatic for victims of domestic violence and their children. But this bill, unfortunately, if passed, will not accomplish that goal. Therapists under this bill, if it was passed, could still provide reunification therapy while billing to a proper medical code. They could just bill it as the generic code for individual therapy, which would be considered a form of mental health treatment and eligible for insurance reimbursement. Members of this committee who were here last year may remember that there was a working session on this bill. I believe it was in February, and it was recommended that the bill be ITL'd and discussed that if reunification therapy is the problem, which I think that is the issue raised by Representative Gay. I also share concerns about reunification therapy and its effects on domestic violence victims and children. So if reunification therapy is in fact the problem, then that is what needs to be addressed by a bill. And this bill does not do that. It doesn't prevent it. It will not stop these situations that Representative Gay mentioned in her testimony. So I just urge the committee to reconsider that as you considered it back in February of last year. Consider that as the issue and vote inexpedient to legislate on this bill. Thank you.
Thank you. Do we have any questions for Ms. Jacina? Seeing none, we'll move on to the next person on the list of people who would like to testify.
The next speaker is Miss Rhonda Hodge. She is unmuted.
Hi, can you hear me okay? My name is Rhonda Hodge. I own Harmony Psychiatric Services in Salem, New Hampshire. I have a 20-year history. I'm a licensed mental health therapist, but I am also board certified in psychiatry. Under that, I'm Dr. Rhonda Hodge. I've been working with children and families for forever. I started my work actually working with foster children who were in trauma situations. I met Betty when I reached out to her about a personal situation. So I'm going to speak to you kind of both clinically, and I think some of the answers, some of the questions that came about, I might be able to answer because I am doing billing. As I own my own business, I do all of it from start to finish. And I think it's important to mention that there's no ICD code for abandonment and there's no ICD code for child abuse. And when you're billing for a family session, yes, we could say maybe post-traumatic stress disorder, but it's really hard to say that when the child is 5 or 6 years old. You're kind of creating things just to be able to bill for something like this. And I actually agree with the last speaker that the idea of reunification therapy is disgusting, to say the least. I always trusted the system, and I always trusted the state of New Hampshire in court, and I'm from New Hampshire, and I started my education at Plymouth State. But some of the things that I'm seeing have just been so horrifying to me. Reunification therapy is it's child abuse. It's telling a child, and I would not say that, like I don't speak that strongly, but it needs to be heard that it is. You're essentially taking a child who has been abused and you are telling them to never trust their gut again. I have never had a patient come in that I would want that to be the outcome. I want them to know that, yeah, bud, like what you know is true. So if you see somebody down the line and you get that same feeling that you got with that person, I'm not going to convince you it's not true just because a judge told me that you have to be around that person. I will never, ever, ever take part in something like that. There will never be a family that comes into my practice that I'm going to reunify them with their physical or emotional abuser. It goes against, it's immoral and it's unethical. Now, of course, there are situations where reunification does make sense. right? Like there are going to be situations where that looks healthy and that could be okay. The situations and the things that I've heard of, it's just such a broad spectrum that it doesn't make sense. You have a female girl, for example, who at 7, 8 years old was physically or sexually abused. And I used female because most of the abuse that you might see, unfortunately, happens to females. But I will not, again, like Betty did, I will not leave out LGBTQ or men. This happens to everybody. But you take that child into reunification with her mom or dad, and you tell her that that was okay and she should have to be around them again, then what happens when that kiddo is a freshman in college? What happens when they are in I'm gonna start crying because it's just like, it's so hard to hear that this is what's happening. And also, I didn't actually hear Betty mention, these reunification therapists aren't necessarily me, they're not clinical. Most of them don't have licenses. I have a situation and I have to be careful with, because I have a personal situation too, of somebody who it's really a business model. They don't have a history of, they don't know about child development. They don't know about personality disorders, and most abusers have personality disorders. They don't have the clinical skills. They didn't go to school for it. That's another reason the ICD codes won't work, is because they're not therapists. They're not licensed in the state of New Hampshire as an LMHC or LICSW, and they didn't do the work. They created a business based on something, and they might have like a supervising going along with it. I also spoke to a state rep because this has been really heavy on my heart lately as I learned a little bit more about it. And similar to what Betty said, he said to me when I was telling him about a case, he said, "I bet you that mom has money." Now, the facts of the case are that the father has a 20-year history of domestic violence. The father abandoned 2 children, abused the child that we were talking about now, went missing for a while during the case for over 6 months, which in New Hampshire, the state of New Hampshire, is abandonment. He beat the mother of his first child twice while she was pregnant to the point of incarceration. Now, abusers don't get incarcerated, so you have to know it's pretty significant. And the judge ordered them, it was the mother's fault that she had a stalking order. In the order, it essentially said it was her fault. Now that is in the state of New Hampshire now. So that's definitely something to look out for. That is a case that went through the Supreme Court. So again, as a provider, I don't even know what to tell my patients anymore when they're in these situations. But what the state rep said to me was, "I promise you, it's because that mom had money and they know that she's going to put more money into the judicial system." So, I mean, this is just like a super layer cake, but I think that it's really, really important that you understand that it's not moral, it's not clinical, there's no psychological basis behind it. And essentially, it's making a kiddo not believe themselves, not feel like they can protect themselves. Like I said, I was horrified. I have 3 master's degrees in psychology, a doctorate. I've been doing this forever. I wouldn't even believe it if I didn't hear it from Betty. I never would have believed that this was actually happening. It sounds like something that came out of the 50s or 60s, and I don't know. It's horrifying, but I definitely can answer any questions you guys have about billing and what that looks like, for sure.
Do we have any questions from the committee? Seeing none, thank you very much for your testimony, and we will move on to the next person to testify.
So that was the last on the list, but I have Paula, you're able to unmute.
Okay. Hi. It's very weird. Every time I unmute, it seems the program mutes me again. I have submitted written testimony on this bill. I think what the last speaker did was, she's accurately describing what is going on in New Hampshire courts right now. Everybody knows about the case that was in Portsmouth and in Foley's Court. It was eventually transferred to Lemire. And after and by the way, there was no subject matter jurisdiction for that divorce. I don't consider this woman to be divorced because the father who filed the petition for divorce was from Washington, D.C. He hasn't lived in New Hampshire during the entire length of the case, and the mother moved out of state long enough to establish child custody jurisdiction in Connecticut before the judge changed custody. The bottom line is, I think the bill does need to be amended to specifically prohibit reunification therapy. It has to be called out, and judges have to know that this is a no-no. Reunification therapy is unethical for psychologists to engage in. So the last speaker is right. The ones that do engage in it are licensed clinical social workers, and they don't have the extensive training. And she's also right that many abusers have personality disorders, and that includes malignant narcissism and sociopathy. So, you know, the judges, under the guise of saying kids need two parents, are forcing these kids to be with terribly, terribly sick, abusive people. Also, the National Council of Juvenile and Family Court Judges have stated that courts shouldn't even take testimony on parental alienation. And you've got more fully the information from them, but they, you know, it says basically, I'm sorry, my dog is bothering me right now. You know, testimony about parental alienation also needs to be prohibited in New Hampshire courts, and the courts aren't doing it, so the legislature has to do that. And the claim of parental alienation is almost always made after an allegation of abuse, domestic abuse or child abuse. You know, and, you know, disgustingly, Judge Foley actually wrote in an order, well, I'd considered giving you an evidentiary hearing, but I decided not to because the GAL says there's no evidence of abuse. The GAL lied. I know Bill Bream. She said that the DCYF report was unfounded. I've seen it. It was an incomplete assessment because the man went back home to Washington, D.C. and never contacted them. The GAL also lied about contacting other witnesses, and she had a stack of affidavits on her desk from people that had seen this man abuse the child, and the child made a disclosure of abuse to her, which she was required to report to DCYF, and she did not do that. And then she wrote in the GAL report, there's no evidence of abuse. So it's disgusting. She told me in her office, we're going to do reunification because it's what the judge wants. And by the way, there was never an evidentiary hearing in this case. Not any. It was denied. And, you know, I'll tell you what the reason is. It was denied because this woman wouldn't go for the alienation assessment with someone that was known to diagnose parental alienation practically all the time. And, you know, if the judge couldn't have his choice of witnesses, he wasn't going to let any in. At some point, there was a psychological evaluation of this kid, and the psychologist recommended no contact with the abusive parent. The judge, before that report was written, prohibited it from being introduced as evidence. So, of course, he never had a hearing, so there was no chance to introduce it as evidence. The New Hampshire courts are a mess, but with respect to reunification therapy, I absolutely agree that this is child abuse. countries like the UK have gone to a different model. There's been so much research on child abuse in the last 20 years, and our laws are so far behind. The UK model is now called the coercive control model. And I did attend, I think it was in December, a Zoom seminar by the DC Superior Court judges, and they are in the process of training all their family court judges on the coercive control model of domestic abuse. I think that's going to better serve people, and I think that's the direction that our courts need to go. And the other thing is with my written testimony, I also submitted for the record the National Council of Juvenile and Family Court Judges Judicial Guide to Child Safety. And I submitted a scholarly article written by a man on parental alienation that basically says that reunification therapy is terrible. I happened to get a hold of him yesterday in preparation for the testimony, and he wished me luck. He said, you know, please make sure the legislature understands this. Questions?
Thank you. Are there any questions for Ms. Worma? I do see one. Representative Grossman, you can unmute yourself.
Thank you, Madam Chair. So I'm not sure who can answer this question. This is currently reunification therapy. There is no CPT code, right?
Actually, oh, I meant to mention this and I forgot. CPT codes are for medical diagnoses. In the mental health field, yeah, it's the Diagnostic and Statistical Manual. So it's actually a DSM code. And that is true. I believe for close to 20 years, proponents of parental alienation have tried to get that code into the DSM, and they have failed every time. It is flat out rejected. And, you know, I think the last DSM revision was, I can't remember precisely when, but it was within the last 5 years. They failed again.
Have a follow-up?
Okay.
Follow up.
Thank you. So if people are being ordered to reunification therapy, and I've heard about why it's not a good idea. How are they billing it? Is it always out of pocket, or are they able to get providers? I think that that's sort of the issue in this as well, but I'm just curious right now, if somebody's ordered to reunification therapy and.
Well, okay, the statute authorizes judges to order therapy, taking into consideration the party's insurance. They very well know that this reunification therapy is not covered by insurance, but as they say, when there's money to be had, they order it anyway. And you know, people have gone broke. They can't afford it. And by the way, there's no statutory authorization for judges to order parental, assessments in the context of discovery. In my mind, that is the judge handpicking his own witnesses, and it is wrong. It doesn't happen in any other area of law. Even DCYF doesn't accept the judge's choice of witnesses, which is mostly what I practiced when I was practicing law. But people are just paying out of pocket. And you know, in particular with Judge Foley, I am perfectly aware that he stated to people, you won't like the order if you don't do this. And, you know, I quoted one Supreme Court case where Judge Foley was the judge, and the wording at the very top of the opinion was the parties agreed to an assessment by Dr. Ben Garber, you know, blah, blah, blah. And then they went on to have the opinion. Well, if Foley's the judge, I can tell you, the mother agreed because she was afraid the kid was going to be placed with the abusive parent. It's not an agreement. It's coercion by the court, threatening to take your kids and hand them to the abusive parent if you don't do this. And it's happened.
Thank you.
Thank you.
Representative Belanger, do you have a question?
I do, Madam Chair. Thank you. My question is to Ms. Wormy. How is DCYF billing for reunification therapy?
DCYF has a statutory mandate to reunify families. They don't call it reunification therapy. What they have parents do is get therapy to address the reasons that they abused or neglected their kids. And then they wait for a recommendation from the therapist to say, yeah, this parent understands that what they did was wrong. The parent has to own up to his behavior and take steps to address their behavior. The current model in custody cases is there's no requirement that an abusive parent own up to the behavior, admit it, apologize, nothing like that. They're just forcing these kids to go with people. And by the way, some of these personality disorders are completely intractable. Malignant narcissism and sociopathy, none of these conditions are amenable to therapy. These are basically lifelong conditions. It's not going to help. These parents aren't going to learn to not be abusive.
Follow up, Madam Chair.
One follow-up, yes.
So because you didn't technically answer the question, but if I understand this correctly, you're saying DCYF doesn't bill for reunification therapy.
Oh, no, it's not done in DCYF. That's not what they call it at all.
Thank you.
Thank you. Next, we have Representative Petrigno has a question.
Thank you, Madam Chair. Thank you for taking my question. I just have a point of clarification. I thought I heard you mention earlier that the CPT code is for physical conditions, but it would be appropriate to have the DSM code for reunification therapy. If that's the case, in your opinion, would this legislation as written address the issue of unification therapy?
Well, there is no DSM code for parental alienation because they refused to put it in the DSM. But no, I think the bill does have to be amended, and my written testimony states that. I think the legislature needs to unambiguously prohibit reunification therapy, or even, I actually think it would be a good idea if the legislature prohibited testimony on parental alienation. The National Council of Juvenile and Family Court Judges recommends that any references to parental alienation be struck from the record because it's junk science.
Yes, thank you. I understand that DSM doesn't have a code for that as well, so I apologize, but you get the gist of my question. I appreciate it. Thank you.
Thank you. Will you take another question, please?
Yes.
Representative Kelly.
Yes, thank you. And thank you for taking my question. Would you consider that this issue might be addressed by restricting the therapies that can be ordered by the court to licensed therapists?
No, because licensed clinical social workers are licensed, and they are permitted in New Hampshire to do therapy. I think I mentioned that it's unethical for psychologists to engage in it, so the vast majority of them are licensed clinical social workers. I do know that one therapist that Judge Foley ordered the woman from Portsmouth to go to turned in her license within days of the judge's order to go there. And we recently discovered that she's back in business, calling it, family coaching or something like that. So she's just gone right along and she's still doing it without a license.
Thank you.
Thank you. Any further questions? Seeing none, we'll go to the next person that would like to testify.
Sorry, Madam Chair, I'm new to this. I apologize. The person that next to speak would be referred to as Cruising Cats.
Hi, can you hear me?
Yes, we can.
Thank you again for allowing my testimony today. I want to also thank Representative Gay for being so perseverant in this very important issue. This again is Alice Giordano. I spoke earlier. I also testified on this very issue a couple of years ago. I just want to make some really quick points of clarification, if I may. I'll be brief. First and foremost, I actually never did, or my child rather, was never, fortunately, forced to suffer through so-called reunification therapy. In my case, the father also wasn't interested in it because in my case, he found out that he would also have to pay for it, and he that didn't sit well with him. So, and then the other, and combined with that, the reunification therapist, who's the most frequently appointed therapist, I think, in the entire state of New Hampshire. She's out of Exeter. She voluntarily withdrew from the case, in part because I stood up to her and I said, we're going to bring this matter to an ethical board and we're going to have you investigated, because this is what was happening with her and what the courts do. And the judges actually push this, is they have the reunification therapist decide on their own, without even meeting the child, by the way, whether or not their very expensive reunification therapy is needed. And the National Association of Social Workers executive director came right out and said, what? That's crazy. That's completely unethical. So combined with that, she voluntarily withdrew. The father, who sent me a text message saying we both know therapy is BS, would not contact her. We never engaged in reunification therapy. Also, another really quick clarification before I make my statement on this bill. I legally re-domiciled in another state because there was never any hearings or trial, because there was always this drive by the judges, not by the parents, by the judge, to force this reunification therapy. So I'm going to use that as a segue into my testimony now on this bill. What this committee really needs to grasp is reunification therapy is being weaponized. They are using it, in fact, to weaponize the abuser against the abused child, and in some respects, the women who are abused. So if you're a protective parent and you assert abuse, and in my case, also very important to point out, all the abuse evidence existed long, and I stress long, before the father filed for divorce in the state of New Hampshire. So there is absolutely no way to even remotely, with a straight face, try to translate this into so-called parental alienation. Essentially, what the courts are doing is they are redefining protection of a child as parental alienation. And they are using reunification therapy in a sense that is fairly tantamount to taking a rape victim and forcing them to go out on a dinner date with their attacker. It is no less demented. It's criminal, in fact. As many other folks earlier spoke, there's I don't really so much get myself involved in the lack of training. certainly there's a lack of training. The woman in Exeter, I think she specializes in eating disorders with adults. But it's whoever will unethically take on these jobs because they're, making a lot of money. You're making $200 an hour. And by the way, it's per head. It's not per family. So if you've got 3 kids and you're going, that's $800 an hour. I know moms that ended up, we had one mom in our group actually that ended up dying. And her family has given me permission. They gave me her case. Anna Korolkova died while fighting Judge Foley's order of reunification therapy so she could get her 3 kids back. She was getting treatment for breast cancer, and she stopped going to her treatments to pay for the reunification therapy that Foley had ordered, again, with no hearing of evidence or trial. And this is kind of how it works. The arbitrary order of reunification therapy almost comes, you could say, before the judge even meets you or even looks at your case. It's really a predetermination that this is what's going to happen. As I said earlier, they declare they don't want to hear any evidence. They just want to go into reunification therapy. I've never been in the sessions. I've heard about them. I know they're expensive. I cannot tell you how grateful I am that we didn't have to suffer through that. I know Attorney Wormer had mentioned that the unethical level of this is to such an extreme that they are willing to use therapists that are under investigation for unethical conduct or professional misconduct. One of those was actually in the process of losing her license to the state of New Hampshire, ultimately voluntarily agreed to surrender it as part of a sort of a secret settlement, if you will, with the state. And in my case, even though we had both parents that were not interested in this reunification therapy, here's Judge Foley. He's just not going to take no for an answer. You've got the other therapist who has withdrawn because she recognizes the unethical ramifications for her. But, don't let a little thing like that get in the way of Judge Foley. He appoints this therapist who's under investigation and threatens me personally that if I don't, he says, I recognize it as an option. But if you don't recognize that option, Mrs. Giordano, you're not going to like the consequences.
1 minute, please.
So, yes, I appreciate that. So what you need to understand is this is being used it's usually essentially a theft by extortion. If you don't jump through our hoops and you pay the money, we're going to take your kid away. Doesn't matter. Evidence doesn't have anything to do with it. Earlier, Rhonda spoke. She broke my heart because I couldn't have agreed with her testimony more. They are essentially, this is just another form of abuse. You are trying to tell a child that their normal fear of somebody who beat them up is not normal. And I want to touch really quickly. I know there's been a lot of discussion of how effective this bill is. A couple of years ago, the state of New Hampshire made the news by passing the first gay conversion therapy bill. And if you look at that bill will guide you to how this bill should be amended. What that bill did is it prohibited therapists from administering gay conversion therapy. And if you just take out the words gay conversion and substitute it with reunification therapy, I think you're going to have your answer on how to solve this problem. Thank you so much for listening to my testimony.
Thank you. Do we have any questions? Seeing none, we'll go to the last speaker. Last 2 speakers. You'll have 5 minutes each.
Mr. Richard Head. Mr. Head, you're unmuted.
Mr. Head, are you there?
I'm sorry, can you hear me now?
Yes.
Apologize, my computer switched mics on me. For the record, again, my name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch, and I just wanted to speak briefly to the bill as written, which would prohibit any counseling for anybody or for counseling that does not have a CPT medical code. And my concern is really an unintended consequences and tying the court's hands relative to counseling without sort of having heard testimony as just sort of the extent of that, other than perhaps CPT codes are not even the appropriate codes that were contemplated in the purpose behind this bill. We have significant concerns that there may be some significant unintended consequences that would limit the scope of counseling and therapies that are appropriate and are necessary. So we just have significant concerns with that. And also, well, with that, I would be happy to take any questions. Thank you.
Do we have any questions for Mr. Head? Seeing none, I'll be with you in we have a question from Representative Altschuler. Representative, go ahead.
Thank you, Madam Chair. I'll lower my hand in the participants list now. Mr. Head, thank you very much for being with us today. You just mentioned that this bill could limit the scope of counseling services that are available. Could you expand on that a little bit?
I'd be happy to, and thank you for the question. What I was meaning is that, so for example, and I'm talking about the bill as written, it would not allow referrals to counseling that has no CPT medical code. And what is concerning is that I don't know that the committee really has a sense of what is or is not a CPT medical code, and that the court, if this bill were to pass as written, may find that some, and one that is universally acknowledged is an appropriate counseling service under a particular circumstance, does not have a CPT code, that would be prohibited. And I think we also heard, the CPT codes may not even be the appropriate one when we're talking about certain mental health counseling. It may be a different coding. So that, if this were to pass, you may unintentionally be prohibiting counseling or therapy that is not in dispute the way some of the others are that were referenced in today's testimony.
May I have a follow-up, Madam Chair?
Follow-up?
Thank you. Mr. Head, is it your experience in working with the courts that that a code of individual counseling can be used to throw an umbrella over a lot of things?
I think so. If I understand your question, actually, I may not understand your question. I apologize.
I can rephrase. There is a code that's called individual counseling.
I see.
In your experience with the courts, have you seen, or would this bill allow for that umbrella to just shield all of these things that we've been talking about today?
I don't know the answer to that. I think there was earlier testimony that it does happen, and it certainly, I can see it happening, but I do not know specifically. So I don't have personal knowledge that would be able to answer that question. I apologize.
Thank you.
Thank you. Are there any further questions? I see Representative Yokella.
Thank you. Thank you for taking my question. I wanted to kind of follow up on Representative Altschuler's question in kind of going at a different angle. Are you aware of any or what counselings might be requested by the courts that are not covered by insurance?
Again, on personal knowledge, I don't have sort of a list. Certainly there are times when insurance will not cover it, or their parties simply don't have insurance, which is also not that uncommon, where you have uninsured parties before the court. So, whether or not insurance is paying for a particular service, as was noted earlier, is a consideration, but I don't have data on that. But that is, as was noted earlier, one of the considerations for the court to take into account when ordering counseling. So I think it's less of an issue of whether or not it has a code for insurance billing, as opposed to whether or not the party actually has insurance, and or whether or not Medicare or Medicaid would pay for it.
Thank you.
Thank you. We have one more person to speak.
Miss Ungarelli, you're unmuted.
Thank you, everybody. Can you hear me? Great. Erica Ungarelli. I am the director for the Bureau for Children's Behavioral Health at the Department of Health and Human Services. Just a couple of comments, and I'm available for questions if you have any to help clarify anything. Most of the commentary that I would have made has already been discussed here today, in that the CPT codes are sort of groupings of procedures that lots of different things could fall under. To Representative Altschuler's question, yes, a lot of things could be grouped under individual, family, or group counseling without an identifier that gets to the actual model that's being used. And this is what I think this is being discussed here today, is an actual model of therapy that is in use. So under the right circumstances by the right provider, this could be billed to any one of those individual, group, or family therapies using those CPT codes. So CPT codes may not be the way in which this becomes addressed. I also just wanted to clarify, I don't represent DCYF, but I've been having a little bit of back and forth listening to the testimony here today. I just want to clarify the reunification work that is done with regard to the child welfare system in DCYF is different than what is being discussed here today. Again, this is a model of therapy, and the work that DCYF does under their reunification mandate is different and does not necessarily employ something like this. And I'm available for questions if anybody has any.
Thank you, Ms. Ungarelli. Did you submit written testimony?
I did not submit any written
If you could, please send that right along.
I can.
Any questions? Seeing none, and also seeing no further hands up to testify, we will close the hearing on House Bill. Oh, just one second. We'll be closing the hearing on House Bill 556. We have 15 people on my sheet that are supporting, one opposing. I think that opposition is probably going to go higher. And we had 7 people testify. So with that, we will close the hearing, and we will break for lunch. I'd ask you to be back a few minutes before 1 o'clock so that we can begin the hearing on House Bill 577. Thank you, everybody. Enjoy your lunch. Representative Alisea, I did neglect to mention that Representative Stephen Smith has joined us and will join us after lunch. He is joining us to replace, not that she can be replaced, Representative Kim Rice.
If Representative Smith could just comply with 91A and let us know where he is and who's in the room with him, that would be great.
Thank you, Christine. Representative Smith, can you do that for us?
I didn't quite hear what you said.
Can you tell us who you are, where you are, and who you're with?
Yes, I am Representative Stephen Smith. I'm in room 211 of the State House, and various staff wander through the office.
Thank you kindly, sir. And we
Do I
are
need-
on lunch break now. Yes, Representative Alisea.
Do I need to put a time as to when he stepped in?
You can ask him what time he stepped in.
Representative Smith, can you hear me?
I can.
This is
What time did you
Representative.
log in?
I believe it was, let's check. Oh, I think it was 11:02.
Thank you.
Thank you very much. Thank you.
See you at 1.
What did I do? Hands off. Mm. Representative DeSimone? Oh, I can't hear. Oh, God. I can't hear you. Can you hear me?
Looks like the room is still muted. So the room will have to be unmuted. If you just go to the computer and hit the, oh, there we
Cody's
go.
doing that.
Perfect.
There we go. Yes,
Well,
Representative Alisea.
I had a technical question, not a question referencing any of the bills. Is it okay to ask it?
Sure.
Okay. So I haven't been clerk for 2 years, and doing it remotely is very different. So someone asked me earlier if I had the blue sheets. I don't have the blue sheets. I'm at home. I've made copies of everything myself. I drop everything off on generally Fridays for Karen and Christine so that they have the information.
They do.
And
Tantamount to the blue sheet is the information that I read in the previous bills. Let me pull this.
I'm familiar with it. I remember and I know how to do it, but not being there, I'm not able to do that. That was one thing. And the second thing is what was the second thing? In the past, the assistant used to get all of the testimonies and all the information and send them out or print them and give them to us. So to have people send them to me and make it my responsibility, I'm not getting paid to do that. So unless it's changed and I wasn't aware, if it's changed and that's what I'm supposed to do, I will do that.
You can
But
just
that's not
forward the email to Children and Family Law.
That's the way it used to be.
Forward everything to Children and Family Law. Yes, I misspoke earlier and gave your name instead of Children and
I
Family.
really appreciate that. I was sort of freaking out. I was like, oh, not more. So I really appreciate that very, very much.
First day on the job.
And one more big favor, if when they start, because it's hard to really understand their names, they're supposed to state their name, where they're from, and if they have testimony. So some of the names I've spelled wrong because I don't want to keep saying, I'm sorry, can you repeat that, please?
Yep.
And it doesn't show on the bottom, on the screen all the time.
For the next 3 bills, we'll do better. And tomorrow I'll do much better. And
I'm not complaining. It's just for help.
No, you're not. I don't
Okay,
take
I
it as a
appreciate it.
complaint at all.
Thank you. Thank you so much.
It's good for us to work together because we need to be a team.
And we've always done that.
Yes, we have.
Thank you. Okay, I appreciate you.
Oh, I appreciate you more than I could ever say.
Thanks. Bye, everybody.
Christina,
Thank you.
Yes.
can you upgrade me again, please?
Oh, of course.
So I hope everybody's back from lunch and you all had a good, relaxing lunch. Is everybody back? Representative Alisea, do you want to do a roll call?
Certainly.
Thank you.
Children and Family Law Attendance. Representative Altschiller. I thought I saw her. Well, she's on the screen.
I'm here. I was having trouble.
Okay. You having trouble?
I'm good now. Thank you.
Okay. Representative Bellinger.
Belanger, I'm in the LOB with
Belanger. Thank you.
Representative Chairwoman DeSimone and John Lewicki.
Representative Cross. Vice Chair DeSimone.
I'm here in rooms 210 to 11 with Representatives Belanger and Lewicki.
Thank you. Representative Grossman.
Hi, everyone. I'm here in Exeter in my studio, and I'm actually alone in my house. Yay.
Oh, congratulations. Representative LeVay.
I am here. I am in my spare bedroom in Barrington alone.
Thank you. Representative Lewicki.
I'm here at the LOB.
Thank you. Representative Litchfield.
Hi, I am here in my home. I am in the room alone, but I do have other people home with me, my children.
Thank you. Representative Long.
I'm here in my house alone.
Representative Petrino.
Hi, I'm here in my home office alone.
Thank you. Representative Smith for Chair Kim Rice.
Representative Smith is here. My 3 children and my husband are home, so they could pop in at any minute.
Okay.
Wrong Representative Smith. This is Representative Denise Smith that just gave you the information.
Yes,
sorry.
Thank you. That's okay.
That's okay.
That's why
I didn't
added
realize
for
there was
Chair.
another Smith. Usually there isn't another Smith on the call.
That's
Sorry.
That's why I said for Representative Kim's.
Oh, okay.
Kim,
I'm
Rice.
sorry.
It's okay. It's fine. So now Representative Stephen Smith for Kim Rice. Perhaps he stepped away. Representative Wazir.
Yes, hi. I'm home with 3 of my children. Nothing has changed.
Representative Yokella.
Yes, I'm still here, home alone.
And Representative Ali Saya. My house guest has stepped out. I just have my puppy. Thank you very much. All set.
Thank you, Representative. I don't think I have to read the disclosure again. I read it this morning. So with all due respect, we will begin this afternoon's hearings with House Bill 577 relative to parenting and divorce cases involving allegations of domestic violence. And I believe we're going to hear from Representative Gay.
Representative Gay, you're unmuted.
Thank you. By the way, it's a good thing to tell people who aren't used to this, that when you tell them they're unmuted, you have to tell them to unmute too. One of them gave you fits because she didn't know that. Thank you very much for taking my testimony. I'll read it very quickly. When a guardian ad litem is appointed to a parenting case in which domestic violence is suspected or alleged, the guardian ad litem shall promptly refer the relevant party to a local crisis center or assessment by a domestic violence counselor as defined in RSA 173.
Excuse me, Representative Gay. We're talking about House Bill 577.
Oh, I am so sorry. Ugh.
That's okay, dear.
Okay. Okay, we're back. I'm not used to doing 4 a day.
I
Yeah.
know, and you have another one after this, so.
And that was
we'll
it.
Be patient. We
Okay.
will be patient.
I don't know if she's in the front. In the front.
Pardon?
Oh, thanks.
Representative Alisea, I will be glad to tell the people that are sending testimony to send it to the entire CFL, Children and Family Law, instead of just bombarding you.
Thank you.
Thank you very much.
Okay. Back to House Bill 577. If domestic violence is identified as an issue in any proceeding under this chapter, either between the parties or between one or both parties and a child or children, the case shall not be assigned to the complex case docket or high conflict docket. The case is criminal and shall be assigned to the Circuit Court District Division or Superior Court. And of course, that needs to be modified because I'm not an attorney. And after getting told by an attorney, it needs to be changed. The wording needs to be changed so that the case shall be assigned to the Circuit Court District Division or Superior Court and be eligible for a trial by jury. We have a strange situation in New Hampshire. It feels strange to me. If you commit a crime against someone who is not in your family, it's handled in Superior Court with a jury. If you commit that same crime on a family member, it goes to family court. The rules there are different, and a lot of times the results and the findings are different, and usually not so punitive and not so protective of the victims. So I realize this is a big ask, and I'm also expecting that two people who keep refusing to acknowledge our bills are any good because they're defending the way things are. I understand that, but the way things are need to be changed. And so this may take multiple steps to make it happen, but I need your support that victims of abuse, domestic abuse, need to be treated in a same way that victims who are not in that same family get justice and get protection. You may have to guide me in saying this, but some of the people who speak against my bills, and of course I don't have a chance to rebut them, but of course they're going to defend the way things are. And it's really a shocker when you find out the people who are supposed to be helping victims of domestic abuse don't offer any way to strengthen the laws. I've asked them directly, face to face, for suggestions on laws that would strengthen their victims in court. And I was told that they were too busy just reviewing bills. So with that in mind, please ask me any questions or give me questions that have information in them to help me. Thank you.
Thank you, Representative Gay. Do we have any questions for Representative Gay? Representative Lewicki?
Thank you, Madam Chair. Thank you, Representative. One of the things that I kind of jumped out at me is it looked to me as if this could possibly be weaponized by putting people into criminal court. Could you perhaps clarify, saying the case is criminal because, or is it always criminal? And if it is criminal, then why is it not tried separately as a criminal case?
I don't know why it's not tried separately. And of course, nobody goes to court until they've had a, let's see, what is it called? A true bill or no bill. Is that term used here in New Hampshire? It was in Texas. You went before
No.
a grand jury and they decided whether you should even go and be charged. So I would assume that if somebody is charging somebody or file against people, they would go through the whole process. They wouldn't just be put on trial. They'd have to, the grand jury would have to assess whether they thought there was enough evidence there to make it worthwhile. But what's horrible is that in the cases of domestic child rape, you can't make it much worse than that, besides trying to blow your children up, which has happened in New Hampshire. Those cases are heard in family court. That's not the right place for them. And so this is my attempt to start the ball rolling, that we get the victims of horrendous crimes to have the same rights as a person in Superior Court after going through the correct steps for a criminal court or Superior Court.
Thank you, Representative.
Thank you. And Representative Stephen Smith, you are here now. Can you state whether you are here or not and give Representative Alicea your whereabouts and with whom you are?
Hi, I am here. I am still in the office and one staffer here.
Thank you. Representative Belanger, you have a question?
Yes, thank you, Madam Chair. And thank you, Representative Gay, for this bill. While I don't disagree that perhaps this should be a separate issue and maybe we could amend that to happen, but correct me if I'm wrong, but this bill states that if domestic violence, which suffice to say, can often tend to happen with these families that are impacted, this would take the case completely away from family court. Am I wrong to assume that?
That is the intent. Not all family court cases have horrible things like that. So it wouldn't get rid of the need for family court. It would just take out violent criminal acts and put them where they should be.
Follow up, Representative Belanger.
Thank you, Madam Chair. And thank you, Representative Gay, for answering that question. Have you spoken with the Department of Youth and Family Services to get data on how many families are impacted by this one specific issue?
No, and let's see how to say this. It seems like in our court system, we have systems that handle DCYF cases. And a lot of different things happen in, I'm not sure how to call it, private divorce proceedings that, are not involved with DCYF at all. Just like the cases, the bills that we talked about before, going through the counseling that's not real counseling. That's just totally not something that affects DCYF. So no, I haven't.
Thank you. No more follow-up.
Are there any further questions for Representative Gay? Seeing none, we'll move on to the next person on our list, which is Erin Jacina.
Ms. Jacina, you're unmuted.
Oh, okay. Thank you. So my name is Erin Jacina, and I direct the Domestic Violence Advocacy Project at New Hampshire Legal Assistance. And I'm here today to testify in opposition to House Bill 577. I would like to address Representative Gay's comments about defending the way that things are. I am here today to testify against these bills because they don't correct the problems on behalf of domestic violence victims. They don't make things safer or better for victims. I'm certainly willing to listen to potential amendments and solutions, but these bills do not do that. Then I would like to say that there was a similar bill which was proposed by Representative Gay last session. That was House Bill 1626. And this committee voted unanimously to ITL that bill 19-0. So there are really two things with this particular bill, and I'll address them each separately. The first one is I think there is some confusion around the complex case docket. When this bill was first drafted, that docket looked very different in our state. It was really one statewide case docket that has now been regionalized, and it is up to each region to determine how those cases are handled. But I believe there may be, I think Richard Head, the court representative, hopefully he's still on the Zoom, so I will let him speak further to that point. Next, I would like to address the issue of making this these cases where there's a finding of abuse criminal and sending them over to district division or to Superior Court. So if there is a finding of abuse made in a parenting case, that does not necessarily make the case criminal. Some of you may know that domestic abuse can take many different forms. It can be emotional abuse. It can be psychological abuse. It can be financial abuse. Physical assault, physical abuse is not, I think that's what many people think of when they think of domestic violence, that there has to be bruises, there has to be broken bones. That is not the case. Abuse can take on many, many different forms, which unfortunately not all situations rises to a criminal level. Our law regarding domestic violence does not encompass all of those things that I just described to you. So somebody may be belittling their partner, maybe putting them down and making them feel worthless. That is abuse, but it may not rise to the level of a criminal act under our law. And so we don't want these family court cases, which are not criminal, to be transferred over to a superior court where judges aren't trained on family dynamics or divorce and parenting law. So in terms of cases being referred to district division, I think the issue is that, and I've heard this in other bills, is that there may be a concern about some of the judges that are hearing these cases. So let's get them out of family court. Let's get them away from those judges to a different division or to a different court. Well, in terms of district division, that wouldn't correct the problem if in fact that was a problem, because the district division and family division are all part of circuit court. So there's the circuit court, and then under that is family division and district division. So the district court judges are the same judges that are also hearing family court cases. So that would not correct the problem if that in fact was a problem. So for those reasons, I'm asking the committee to vote inexpedient to legislate. And I will just add that I am happy to, at any point, meet with any representative who is sponsoring a bill to provide any sort of feedback and amendments, which is exactly what I did with these bills when they were brought forward last year. Thank you.
Thank you, Ms. Messina. Any questions? Representative Altschiller. Can you unmute yourself?
Yes, can you hear me?
Yes, ma'am.
Thank you. So, Ms. Jacina, could you, in your description of the differentiations between the courts, I think right at the front end of that, you mentioned that in some cases of domestic violence, it doesn't rise to the level of a criminal finding or a criminal case.
Mm-hmm.
So could you just go over that one more time?
Sure, absolutely.
That's my question, is a repeat of that piece of your testimony.
Sure.
Thank you.
Absolutely. Thank you for the question. I'm happy to do that.
Yeah.
So in the example I gave, you have two parents. They share a child. one parent is abusive to the other parent, is putting that person down, is saying, I wish you were dead. I hate you. You're so fat. You're ugly. You're worthless. You do nothing for this house. I contribute everything financially. You do nothing. What do you do for this family? That's horrible. And that's abusive. And that is uncalled for. And I think we can all agree that that is not appropriate behavior. But if that person, in this case, let's just say the mom, takes that to a police department, the police department is not going to charge that person with a criminal act. They're not going to say, we're going to arrest you, we're going to charge you, we're going to bring this to the county attorneys, because how are they going to charge that? Our law doesn't really account for that. If there was some criminal threatening involved, yes, perhaps in that situation. But the reality is the police are not going to charge that person. So it's not a criminal case, and we don't want those cases to go to Superior Court where they do handle criminal cases. We want these cases to be heard by judges who are trained, and we want them to be heard by judges who understand RSA 458 and 461A. And honestly, we don't want people involved in family court cases to feel like they're involved in a criminal situation. We want to support families. We don't want to make them feel like they're doing something wrong. That's not to say that there is not inappropriate and abusive behavior going on in family court and with litigants involved in the family court system. There absolutely is. And there are avenues to address those things.
Thank you.
Thank you. Representative O'Kelly, you have a question?
Yes, thank you. And thank you for taking the question. It seemed, I just wanted to clarify, it seemed that you, on one hand, said that you were advocating for this to not be moved to the circuit court because those judges weren't trained. But then in the next sentence, you said that if they were moved to the circuit court, it would be the same judge that hears it. So can you elaborate on that?
Sure.
Comment?
Thank you for the question. No, it's two different. So Superior Court is separate from Circuit Court, completely separate. So within Circuit Court, you have family division and you have the district division. So the judges, most times there's overlap between the district court judges and the family division judges. They are hearing both kinds of cases within the Circuit Court. Does that make sense? I can explain that a little better if necessary. But I don't think they should be referred to Superior Court because those judges don't handle family law cases. But within the Circuit Court, you might have a district court judge who also hears family court cases because they are cross-trained.
Okay, thank you.
Thank you. Representative Grossman.
Thank you, Madam Chair, and thank you, Ms. Jacina, for coming today and sharing your testimony. I just have a question regarding the definition of domestic violence. So how does it get defined? And is emotional or psychological abuse part of our definition? And then I do have a follow-up if other states do include emotional and psychological abuse as part of domestic violence cases, if there is any. I'm not very familiar, so.
Sure. So thank you for your question. So under 173B, which is the law that we use to help a victim get a protective order from domestic violence, the definition, abuse means the commission or attempted commission of one or more of the acts described below. And those acts include assault or reckless conduct, criminal threatening, sexual assault, interference with freedom, destruction of property, unauthorized entry, and harassment. So it doesn't explicitly say psychological abuse, mental abuse, any of those things. Certainly, you know, you could make a case there may be some criminal threatening in a situation that the example that I provided, that there could have been some criminal threatening within some of that psychological abuse, but for the most part, it doesn't encompass those things. And so that's what we're left with at the moment. And I'm sorry, what was the other part of your question? Whether
if there's any other case law, like our other states, is there any movement towards that emotional and psychological piece being included in case law?
So I don't have the statistics in front of me. It's certainly something that we talk about kind of in the domestic violence advocacy arena, is whether or not, and I think some states have probably moved to do this, to include psychological abuse within the definition of abuse. Because that's frustrating, because we know that that is abusive and coercive controlling behavior, but our laws don't always include those things. So I can't answer your question directly as to which states. I think there are some. I could certainly get that information for you. I just don't have it at the tip of my fingers at the moment.
Thank you.
Any further questions for Ms. Jacina? Thank you, Ms. Jacina.
Thank you.
We'll now go to our next person on our list, Rhonda Hodge.
Ms. Hodge, you have to unmute.
Hi again. I hope you guys had a nice lunch. So I just wanted to speak to a couple of things that were brought up, and I didn't hear her name, but from the Coalition Against Domestic Violence, I mean, she brings up a lot of really great points. But one of the first comments, there's not going to be any data. And unless you're working for the coalition, or you're working, or you have a passion for really helping this particular population, there isn't going to be any data because it's ignored, right? So if, for example, I have one case right now, that's one of my patients that I'm working with, and I'm honestly, the coalition doesn't have enough people or enough time to be able to help as many people. So I try to help as much as possible as well. Who a judge just told her she's in a domestic violence situation. She's been unable to get a restraining order. We've shown pictures of her having the ex having guns, saying he's going to kill them. There's pictures of abuse. This man has never been arrested. I mean, I think it's really important that we point to the fact of how bad it really is and how nothing is really actually being done. Even if this particular person was to have a restraining, in family court, the point I was trying to make is that the judge actually called her a spoiled brat. And they're allowed to be abused. So that's one point. But the other point is that even if she had a restraining order, or even on that family parenting order, there is a restraining order. It is civil and it doesn't mean anything. So even if she was to have a restraining order, speaking about another patient whose tires were slashed, and she called the police, and the police said, well, we can't prove it's him, so there's nothing they can do. So these people aren't being arrested. There's criminal threatening happening. There's physical abuse. It's not being treated as criminal. They go into the family court, and it's almost as if when they're in the family court and they're talking about custody and divorce and all of these different things, it's, well, this happens in families, right? This is what it looks like. If I have the most horrifying pictures from some of my patients, and I help them, like I said, I help them kind of put it together so that when they go to an attorney or they go to the police, they're able to speak, because these men and women, but mostly women, are speaking while their voice is completely shaking. They're having to go to court. They're having to face their abuser. And one, that's not fair. They're expected, they're going to look weak. It's going to look like it's their fault. Their abuser, the state of New Hampshire, is telling them that they didn't do anything wrong, right? When you do something wrong, you get arrested or you're held accountable for it. I think that's the biggest part that Betty's trying to make from this, is that there's no accountability in family court. And like I said, there's not going to be any data because there just isn't any accountability. I think one of the very first comments too is, I don't know who it was that said it, and I just want to bring up the bias. I'm definitely not trying here to hurt anybody's feelings, but the very first question that said is, can't this be used as a weapon? So if we bring this over to family court, over to criminal court, couldn't this be used as a weapon? That is the reason that I am speaking right now. Women specifically, mostly, they don't lie. Do you know how hard it is? That's the first thought, is that women are lying. They're using this as a weapon, and they have to be able to prove it more than their abuser has to prove they didn't do it. That's just society. That's what we go to, is that parental alienation. It's in us, it's in our society, it's how we're raised. I promise you that going to family court or going to court and saying that you were raped, saying that you were physically abused, these people are so vulnerable. It is so scary. Even if it was barely anything, just walking into court and nothing happened to you, you probably get nervous. People aren't going to go to those lengths unless they are, a very extreme sociopath. So I think that assumption, the very first assumption, is that people are lying and they're weaponizing it within their divorce case. I just really need this group to hear that that's not true. I want the assumption to be that people are telling the truth, not that they're lying. We can look to find out, right? But the assumption would be that they're telling the truth. And that is just something that societal is inbred in us, is that that it's used as a weapon, is that they're lying. And then, like I said, that the restraining orders and the stalking orders, nothing happens anyways. So there isn't going to be any data. It's not considered criminal. Families fight, right? People get hurt, kids get hurt when they're in toxic relationships. And that's the frame of mind. I've never actually had one of my, the people that I've been working with in some of the most horrific stories, including sexual abuse from a mother and boyfriend, nobody's ever been arrested. So it's never been treated as a criminal case. And those people, the abusers, typically get custody. So that's all. I also sent some clarification on billing and ICD codes during the break, because I knew that was confusing about the last one at the end.
Thank you. Do you have written testimony?
I do not, but I'm happy to do it.
Please send that to the Children and Family Law site.
Absolutely.
Thank you. Any questions for Ms. Hodge? Seeing none, I will let you know that Ms. Hodge is the last person on my written list to testify. Although I do see a couple of hands up, and I believe it's for people who want to testify. And the next person with their hand up would be Paula Worma. Could you please state your name, where you're from, who you're representing, and whether you're in support or not in support?
I'm in support of the bill with an amendment. And I do believe that the language needs to come out.
And where are you from, and who are you representing?
I'm representing myself. And I respectfully decline to tell you where I'm from, because I am also afraid of one of the abusers that we're talking about.
Okay.
I don't live in New Hampshire anymore, but I practiced my entire legal career in New Hampshire.
Okay.
With respect to, I had a kid that was in a very abusive relationship in her 20s. And at the time, my husband and I were estranged from her. But we knew about the abuse because in 2 years, we watched the insurance pay out $100,000 in ER bills. At this point, it was many years ago, and I forget. I forget precisely how many trips that represented. I do believe that these cases need to be heard in a different court. And my thought is that Superior Court judges are the best trained with respect to the rules of evidence. And that's because the criminal defense bar files a lot of motions, you know. There are many, many evidentiary motions in criminal cases. And I don't think the family court judges are well trained on the rules of evidence. And I'll just give, you know, aside, again, I'm supplementing my written testimony that you people should have had from before. We've talked about, there actually is a New Hampshire case law that says a parent that alienates a kid should not benefit from the behavior, and therefore it was okay to give custody to the other parent. The facts of the case were pretty clear that what the one parent that lost custody did was kind of turn her kids against the father after the divorce was filed. Let me tell you what there's not a case on. There isn't a case on parental alienation, whether it meets the evidentiary standards for admissibility. I think it would be an easy case to say that a Superior Court judge, if somebody said, let's have a hearing on whether or not parental alienation is even admissible, which, by the way, is probably, by the time you pull in experts, a $50,000 hearing. Not anybody can afford one of those. You know, it involves expert witnesses, and probably a lot of them would be coming from outside the state. But a Superior Court judge would get that and would go ahead and schedule the hearing and have the hearing and listen to both sides of the argument. You know, but that said, something like parental alienation is highly, you know, it's been struck down and declared inadmissible because it's junk science. And I have to tell you, you know, when a family court judge, and I'm just going to read from my testimony for a minute, Judge Foley stated in his order dated January 10th, 2019, in a case, I've considered the idea of setting an evidentiary hearing on the issue of whether Mr. whatever abused the child. The GAL said there was no objective evidence of abuse. If I found abuse by Mr., it would do little to alter my obligation to reunite him with the child after he addressed his abusive behaviors in some way in an appropriate therapeutic setting, RSA 169C19 and RSA 169C23. He's absolutely wrong on the law. This, you know, a custody case is not a child abuse case. And frankly, he might as well have written, I considered the idea of affording you due process, but I decided against it. I always mandate kids spend time with their abusive parents anyway. His entire judicial philosophy, and mind you, he was the only complex case docket judge for many years. It conflicts directly with the factors of he has to identify abuse and how it's impacted the child on the relationship between the child and the abusing parent in making a custody decision. That's RSA 461A6, Roman numeral 1J.
Excuse me, Ms. Werma, are we still talking about House Bill 577?
Yes.
Thank you.
So, you know, I don't think family court judges are well trained. I think sending a case to a Superior Court would be a much better thing to do in cases of abuse. I think it would be a good idea to amend the bill and also state that these people are entitled to a jury trial on the issue of abuse. Perhaps not the other issues identified in the divorce, but in particular now with the current system of the judges picking the GALs and the judges picking these alienation evaluators, they're picking their own witnesses. And I don't think a Superior Court judge will do that, or he would certainly be much less likely to, or she.
Thank you very much for your testimony. It's been helpful. Are there any questions? Representative Belanger, will you take questions, Ms. Warma?
Oh, yes.
Thank you. Representative Belanger.
I have two. Yes, ma'am. Thank you. I will ask one at a time and then follow up. Yes, ma'am. When you referred to judges picking GILs, are you familiar with the situation that you can petition for your own GIL? You do not have to have it appointed by the court.
I am not aware of that, and I have never seen it happen. Although the last case I was involved with was the case in Portsmouth and Foley's and Lemire's court, and I actually had not done a custody case for years before that. But this case was an education for me, re-education.
Follow up, Madam Chair. And just for clarification, I have a GIL in my guardianship case that I asked to be appointed. The judge did not appoint the GIL himself. When you refer to judges aren't trained in family court, can you provide the data that you have on that?
Well, when they're making, they're appointing these evaluators that they aren't statutorily even permitted to appoint. The direct answer is no, I don't have data, because I did a right to know with the judicial system, and they told me that I asked for a table of contents for judicial training for family law court judges, and they declined to give it to me. Now, I will say that I have not reissued that request for information since the New Hampshire Supreme Court case about the right to know law last year, I think it was. But they refused to give me the name of the trainers, any contract trainers. They refused to give me a table of contents of how they're trained. They refused to give me any information on how judges are trained.
No more follow-up.
Thank you. Any further questions for Ms. Warma? Seeing none, thank you, Ms. Warma. And we have one more hand up. Richard Head, I believe you want to testify, and if so, please state your name, where you're from, whether you support or do not support the bill, and how much time do you need?
Mr. Head, you have to unmute.
Sorry about that. I thought I clicked on it.
Mr. Head, let's try that again.
Let's try that. How's that? Better now?
Yes, thank you.
Perfect. Sorry about that. For the record, my name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. With the chair's permission, maybe 5 minutes.
Sure.
And I'm primarily testifying for information. The bill had, in terms of background, as I think you heard before from Ms. Justina, the circuit court is made up of 3 divisions: the family division, district division, and probate division. And this occurred in 2011 when district courts were eliminated and consolidated into the circuit division or circuit court system. And as you heard before, previously there was a system of marital masters that, with the creation of the circuit court system, have been fading. So as marital masters retire, they are not being replaced with marital masters, but they're being replaced with circuit court judges. And I believe there are only 2 masters still in the system. And as those 2 retire, they will not be replaced with other masters, but again, with circuit court judges. Circuit court judges are incredibly busy. They're incredibly knowledgeable of rules of evidence and rules of court. And they do, there are some that focus more obviously on family, and some do it. I don't know if any of them, I don't know how much are doing it exclusively, but there is, with the circuit court system, cross-training and in district division and family division types of cases. So you have these very knowledgeable judges in rules of evidence, rules of procedure, who are hearing cases both in the district division and in the family division. When domestic, and just rough numbers, family division in 2020 had about 15,000 cases. Of those, about 3,600 had some, 3,700 of those had some allegations of domestic violence involved in the case. And these are not criminal cases. So unlike, as the sponsor said, and I get what she was saying, when Representative Gay was saying that in Superior Court, when it's not a family member involved, they're in Superior Court and they're being charged criminally. Family court is not a criminal court. It is a family court, and it's governed by the rules and the statutes that govern family, parenting, divorce, whatever the issues may be. That would not change if it's filed in Superior Court. The same rules apply, the same statutes apply, the same procedures would apply. So simply moving it to Superior Court is the only impact is that you're moving it to judges who do not hear these types of cases every day, do not have the depth of knowledge of family practice and procedure, and it's a very complicated area of law. So you would not have that level of experience if you moved these into the Superior Court system, and that's a significant concern. The other aspect of the bill itself, which would be, basically, it really is fairly simple. It simply says the case shall not be assigned to the complex case docket or high conflict docket. That type of case assignment is, essentially a court function of how do you allocate the resources and the very limited resources of the judicial branch in terms of hearing what are, in fact, they tend to be more complicated cases. They tend to have more issues. They tend to involve a great deal more time. And in the just sort of efficient management, as efficient as we can be, the efficient management of cases, those are allocated within the family division, the sort of regular track and then the complex track, in order to sort of keep the more complex cases from slowing down all of the other cases. And sort of an essential management tool that the circuit court has developed. And also, as you heard from Ms. Justina, or Attorney Justina, this is not current. It's no longer a single statewide, but it is regionalized and mostly within the various circuit courts. And there's essentially it's assigned to a more seasoned and experienced judge in these areas. So those essential functions of the management of the court docket are why we have an administrative judge, and why Judge King is works very hard in terms of managing how these dockets work. And then the bill also says the case is criminal and shall be assigned to the circuit court, district division, or Superior Court. And in fact, these are marital cases. They're not criminal cases. So criminal cases are brought by prosecutors, and I understand and I get the issue of whether or not prosecutors are filing these or police are charging, but these are family and marital matters. They are not criminal matters held to a criminal standard of proof where somebody is going to go to prison or have a criminal penalty at the end of the day. These are marital cases that are governed by the statutes and the rules of the court, the statutes that you all have laid out relative to parenting, divorce, and reunification. So I don't think this would accomplish what the sponsor wants, and in fact would be substantially detrimental to those cases, because they would be moved into, if it stays within the district division, essentially the same judges, and two, if it's moved into the Superior Court, you are talking about a system that does not have the same number of judges, the same experience in marital matters, and would ultimately create significant management problems, both in the docket, but also in terms of the outcome of these cases. So I do think, while it may be well intended, and I appreciate that, I think the bill itself creates significant issues and concerns relative to the legislative body really implementing a docketing system for the court, which it's doing to manage a very heavy caseload of these types of cases. I guess I'll rest with that, and I'd be happy to answer any questions. Thank you.
Thank you, Mr. Head. Any questions? I see one hand raised, Representative Altschuler.
Thank you very much, Madam Chair. Thank you, Mr. Head, for being here for the day almost. And
you all get the longer day.
Yeah, and answering all of our questions. So I want to go back and ask, I have two questions for you. One is, could you clarify, you just mentioned in your testimony that if domestic violence was identified in a court proceeding, then instead of the what this bill seeks to do, instead of the referring it to a different docket, it would this bill would actually require that it be referred to county attorneys for prosecution to draw up charges. Is that what you're saying?
No, I thank you for the question. So I appreciate that, because I obviously was not clear. What I'm saying is that not every domestic violence case goes into the complex case docket. That is an element that is considered in the complex case docket assignments, but they don't all go there. What I'm suggesting is that by virtue of what this case is, which is a family case, it is not a criminal case as it is before that family court judge. And that would not change if it is moved into the Superior Court. It is still a family court case. It is still a family case, and it is always going to be governed by the family court or the family law statutes and rules. What I am saying is that these are not cases that are being filed by prosecutors or law enforcement. These are cases being filed by private individuals involved in family matters. So if a prosecutor files the case as a criminal case, which is not what we're talking about here, if a prosecutor files, then depending on the nature of that charge, whether it be a misdemeanor or a felony, it would be filed in either the district division or the Superior Court and handled as a criminal case. And sometimes you can have a criminal case involving a party involved in a marital case. So the claims are different, the types of cases are different, the burden of proof is different, and the outcome is different. These cases that we're talking about today are family court, and without regard to what judge is deciding it, the outcomes are family-related outcomes. They do not result in prison time. They do not result in criminal penalties. Those are reserved for cases that are filed by prosecutors as criminal cases, and that's not what we're talking about here.
May I follow up, Madam Chair?
Yes, follow up.
So, Mr. Head, when there are criminal cases that involve parties who are also subsequently, concurrently involved with a family court case, does a criminal court case or finding inform the family court case?
It could, yes.
It could, okay. And one last question, Madam Chair, if I might?
Sure.
In a family court case, if there is no, if a party are involved in a just strictly a family court case, and there are allegations of domestic violence that don't rise to the level of what our statutes have at what our laws have as a criminal prosecution, within the family court structure is the, isn't the what is the word I'm looking for? Do we not have to just rise to the preponderance of the evidence versus clear and convincing in a criminal?
Yep, the beyond a reasonable doubt and clear and convincing are all the higher standards that a criminal court, and sometimes that's why you may not see a criminal case filed, because the prosecutor may have reviewed the evidence and for whatever reason decided that at that very high level of proof, whether it be the victim or the way the victim didn't want to pursue a criminal case, even though it may be an element in the family case. There are a whole host of reasons why, but there is a different burden of proof and a much higher burden of proof on a prosecutor in a criminal case than what you see before in a family law case.
Thank you for the clarification. Thank you.
Thank you. Representative Yo Kelly, you have a question?
Yes, thank you. Thank you for taking the question. A previous speaker talked about the training for family court judges. Would you be able to send the committee some information on what trainings the family courts have?
I'll see. I'm happy to ask Judge King his, and I'll follow up with him. He had, as you may have seen in the paper, death in the family. So he's not here today, but I'll follow up with him and let you know. I don't know. I just don't know what's available. So I'm not trying to avoid the question. I just don't know what he has that would be available for me to give to you, but I'll check.
Thank you, Mr. Head. I have one more question. Representative Long.
Thank you, Madam Chair. Yeah, thank you, Mr. Head. Could you give me a little bit of experience with respect to pro se litigants? A lot of these bills I'm looking at, this one also is, for the low to moderate income person who cannot afford attorneys. How would this affect their, and this is on both sides, the one accused and the one accusing. If neither one of them have the wherewithal to pay for some of this stuff, how does this affect their case?
I guess I'm not sure it would, in the sense, as I said before, no matter who the judge is and what the building is you're walking into, whether it be a Superior Court building or a Circuit Court building, the rules are the same. You have fewer Superior Court judges, so you may have a greater backup. In Circuit Court, to be more direct, the vast majority of people are unrepresented. You have relatively, in terms of the total, you certainly have judge or lawyers in the Circuit Court, but there is a huge percentage of parties in Circuit Court who are unrepresented. And, I think by moving it into Superior Court is just physically different. It feels different. I think it may be more intimidating. But it's also hard for me to really know that because I've been practicing for 30 years. So it's more familiar to me, but I think that atmosphere is certainly different than the Circuit Court. And I think the Circuit Court is better, has greater experience in dealing with pro se parties. I think you just see a greater percentage of pro se parties in Circuit Court where the clerks are more familiar with that environment, the judges are more familiar. And as I said before, this subject matter is a Circuit Court subject matter, not a Superior Court subject matter. So I think you would have greater difficulty with pro se parties in a Superior Court setting. But that's my personal view. I don't have any evidence of that.
Okay, so a quick follow-up for me, Madam Chair.
Yes, a quick one.
Yeah, so I've heard from constituents who have said that in circuit court, the clerks do help out quite a bit. So I'm hearing that in Superior Court, that luxury may be less to happen.
I think not by any fault of anybody, but I think the experience level is much different in Superior Court than Circuit Court, given sort of the volume of cases and the numbers that are represented by lawyers and those that are not. And I think it's just a more familiar experience for the clerks and staff in the Circuit Courts than you see in Superior Court. And again, it comes in part down to just sheer volume.
Very good. Thank you.
Thank you. Thank you for the question.
Thank you, Mr. Head, and thank you for all your great questions, everyone. With that, I'm going to close the hearing on House Bill 577. We have 11 people supporting, 2 opposing. That's what's on my sheet. The numbers could be different. You can check the blue sheet in the office later if you so choose. We had 5 people testifying. Thank you. And with that, we will open the hearing. We're about 35 minutes behind schedule, just to let you know. But I want everybody heard, and I want everyone who wants to testify to testify. So with that, we'll open the hearing on House Bill 548 with Representative Gay introducing her bill.
Thank you. And I really appreciate you giving people time to testify. It's nerve-wracking, as we all know. Okay, this is on 548, and the gist of it is, when a guardian ad litem is appointed to a parenting case in which domestic violence is suspected or alleged, the guardian ad litem shall promptly refer the relevant party to a local crisis center or assessment by a domestic violence counselor as defined in RSA 173C1 Roman numeral 3, and in appropriate cases, comply with mandatory reporting requirements for child abuse under RSA 169C29. The guardian ad litem shall also determine whether law enforcement completed a lethality assessment protocol regarding any party to the proceeding. When I've talked about this before, I was told that it wasn't fair to refer a party, a victim of domestic violence. It wasn't a good idea to refer them to a domestic crisis center. And I'm thinking, if they choose not to go, that's their choice. This is not forcing them to go, but this is where they're going to find people who know what the situation is, who can advise them. That's why they're there. And so I'm prepared for the same person to criticize that again. And then somebody said they didn't like this idea about telling the guardian ad litem that they should be checking on if there was any lethality assessments. Police are supposed to write up a lethality assessment when they go to a domestic disturbance. But unfortunately, that's not done very much. Perhaps if they started getting asked about it, they would. And certainly those who have done it, the information is helpful, because the people, it's one of the problems is that under this mindset that has been imposed on courts that we're trying to overturn about alienating, parents being alienating, and is that the person who says there's violence or abuse going on is automatically suspect for making it up. And so I was hoping, but this didn't work. I was hoping that if they went to the crisis center, got interviewed, assessed by a specialist, a domestic violence specialist, they would have a report to cite. But that's not the way our crisis centers are set up. And I do appreciate Representative Altshuler trying to explain to me how the system works, because we know the crisis centers do a huge amount of good for victims of abuse, but they cannot testify. So I figured, well, the police are supposed to be writing these lethality assessments. So at least the guardian ad litem could see if there are any, because that would be useful. What's really disappointing to me is to find out that in New Hampshire, at least, and I understand that in many, it's standard practice around the country. Here you have guardian ad litems, GALs, GALs, appointed for, and Representative Belanger was lucky, if I understood him, to say he did get to choose his guardian ad litem. You can shake your head yes or no. Yes, so that was great. But all the people that I've met and have suffered terribly in court, they didn't have a choice. And the gal said, oh, you've alleged there's domestic violence or domestic abuse, so your children have to be, they have to go and have these sessions with the parent that they don't want to be with. And yet we find out that here the gals have a tremendous responsibility and a lot of credibility with the judges who appoint them. Only they're not required to have any kind of psychological education. And they darn sure don't have any legal training either. They might have a smattering, a couple of courses here and there, but they are not psychologists and they are not attorneys. And yet the child's future depends upon these people. So some people would just really like to do away with GALs. So maybe we ought to just make sure they have a lot more training than what they have now. The child, one of the things that's really upsetting to find out, children are automatically assumed to be unbelievable. They are not permitted to speak. So in a famous case in California, the daughter of a famous wealthy attorney was forced to live with him. They followed all those awful rules we've been talking about. So they took her away from her protective parent and gave her to him, despite all the allegations of abuse by both the daughter and the mother. The gal refused to report the abuse. After 2 years, the girl was, now she was 11 when she was awarded to him. After 2 years, the girl was able to run away. When she was picked up, she was put in the juvenile section, what do you call it? The juvenile legal program for the state. In that court, she was able to speak and about the abuse, and she was placed back with her mother. And there is a fabulous article that she wrote at the age of 16 that is, you would never guess it was a teenager who wrote it. It was excellent. And if I can find the link, I will include that in my testimony. Just yesterday, I wish I could show you this, but you know, I'm not a panelist. This is just published on the 2nd of March. 31 Missouri judges recused themselves from lawsuit alleging family court guardian and psychologist orchestrated money-making scheme. Gee, where did we hear about that before? So it's just sad that our system allows very untrained people to be such legally representing children who aren't ever allowed to testify or to be interviewed and have their testimony ordered. The only persons who can speak on behalf of the child are the ones who are appointed by the judge. So that just totally needs to change. So all I did in my bill, all I could see that I could do was ask them to recommend that the victims, the alleged victims, I have to say alleged, recommend that they go to a place that is set up to help them. And the other is to call the police, find out, was a lethality assessment ever made? So with that, I will take any questions if you want, or advice.
Thank you, Representative. Are there any questions for Representative Gay? Representative Altshuler, you have a question?
You need to unmute.
You need to unmute, dear.
So sorry. Thank you, Madam Chair, and thank you, Representative Gay. I'm wondering if you had sought out the advice of the Lethality Assessment Protocol Steering Committee and what their opinion was?
Well, I'd like to, but I'm unaware of them.
Okay, thank you.
You can tell me how.
Thank you. Any further questions? The next person on the list that I see is a David Goldstein that wants to, and I don't see him on the list. Well, you have a question? I apologize. I have a question for Representative Gay from Representative Belanger.
Thank you, Representative Gay, and thank you, Madam Chair. Representative Gay, when you refer to guardian ad litems or GALs not being psychologists or attorneys, they are mandated reporters, however, but are you aware of any that are attorneys, as I believe there are quite a few in the state?
Oh, I'm sorry. I am not aware. I just know about the cases that have been brought to my attention where they weren't. There's nothing that says they can't be, and they are paid by the parents. And one of the problems is in the cases that I've been made aware of that bad things are happening, they're representing the parent who's paying for them much more so than they are the children's best interests. That doesn't mean that all of them are doing that. It's just that that's what I'm trying to prevent from continuing to happen.
Thank you. The next person we have on our list is a David Goldstein. Are you here? If you're here, can you please raise your hand? I see one person signed in as a wise man. And if that's you, Mr. Goldstein, please raise your hand.
It's Chief Goldstein, Madam Chair, and I don't know that he's in the room.
Well, thank you for clarifying that. He did not sign in as chief. Otherwise,
okay,
I
just let
would
you
have.
know.
Thank you. I appreciate
Oh,
that.
you know what? I'm sorry, he just got called. I got a text message. He has just been called away.
Okay.
A duty call. So.
Okay, well, we'll take the next person on the list then, and maybe he'll be back by that time. And the next person on the list is Erin Jacina.
Thank you, Madam Chair, and thank you, members of the committee. Before I get into my testimony, I just want to say thank you for taking the time to hear my testimony today. You've heard a lot from me today. So thank you for your time and for all you are doing. I'm sure it's a marathon day for you all. Again, my name is Erin Jacina, and I direct the Domestic Violence Advocacy Project at New Hampshire Legal Assistance. I'm here today to testify in opposition to House Bill 548. As I mentioned previously, this bill is also similar to a bill that was proposed by Representative Gay last session. That was House Bill 1626. And this committee voted unanimously to ITL that bill 19-0. Respectfully, this bill is well-intended and meant to protect victims of domestic violence, but it does have potential to cause even greater harm to victims. This bill would require a GAL to refer a party that they suspect is a victim of domestic violence to a local crisis center. This can create 3 issues, and I'm going to walk you through those 3 issues. The first one is that without proper training or screening techniques, the GAL may misidentify the victim in the case and instead refer the abuser to the crisis center. So if the crisis center then starts providing services to that person, the actual abuser, in some cases, it may preclude the crisis center from providing services to the actual victim. It's possible in that situation that the victim in that situation could be referred to another crisis center, but it may not be the crisis center that is anywhere close to them, and it would be more difficult for the victim to access those services, which we certainly don't want to make things more difficult for victims. Issue number 2 is that choosing to seek services from a crisis center is empowering. One should not be required to seek them. While this bill does not require a victim to accept services from the crisis center, the victim may feel obligated to do so because a GAL, a court-appointed official, is asking it of them, and they may be concerned that non-compliance will look uncooperative in the GAL's eyes. And lastly, so the third issue is that this bill has potential to inadvertently waive the privilege under 173C, which is the statute that protects the privilege between the victim who is accessing crisis center services and the crisis center counselor or advocate. So if the party starts receiving services from a crisis center and discusses those services with the GAL, who then uses that information to make a report to the court, that may be considered a waiver of the privilege, and then all communication that victim has had with the crisis center may be considered fair game. And we certainly do not want to risk that safe space becoming another avenue to further the abuse of that victim. So for all of these reasons, I respectfully ask this committee to vote an expedient to legislate on House Bill 548. Thank you so much.
Thank you, Ms. Jacina. Any questions? Seeing none, thank you very much for your testimony.
Thank
Take
you.
a deep breath. You've been awesome today. And we will go on to the next person. We don't have anybody else on the list. However, I do see 2 hands raised. So the next person will be Paula Werma. And I will give her 2 minutes.
Okay. I'm sorry, my computer keeps remuting me after I unmute. I don't have a lot to say about this. I was actually pretty impressed with the testimony of Ms. Jacina. I think the bill could be amended easily to require the judge to give a victim of domestic violence information about a crisis center. But again, you still have the worry that if the person doesn't do it. The other thing you people need to know is that statistically, nationwide, when abusers fight for custody, 70% of the time they get it. And New Hampshire is no different in that respect. It's a very hard problem. This bill might do something about it, but I think it does need to be amended. So it's an intractable problem, and it's an intractable problem in New Hampshire courts.
Thank you. Any questions for Ms. Werma? Seeing none, we'll go to the final person on our list, Richard Head.
Thank you, Madam Chair. Just to make sure, can you hear me okay?
Yes, I can.
Excellent, thank you. For the record, my name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. You should have received yesterday written testimony from me regarding this bill. And I'm happy if you ask it, I'm happy to resend it. One of the primary concerns that we have with this bill is the conflict that this creates with the statutory role of a guardian ad litem, which the statute under 461A16 says is to gather information to assist the court in determining the best interest of the child. The guardian ad litems are always suspect of having a bias one way or the other. And it's sort of an inevitable aspect of the job. And these are typically very high conflict situations in which a GAL is being appointed. And there's a history, they're difficult cases, to say the least. If you ask the guardian ad litems to start taking what, at some level, even if it's a minor level, an advocacy position, which is essentially making an evaluation of is violence suspected or even alleged, and this gets to the point that was described earlier, the mere allegation of domestic violence would require a referral to a local crisis center or assessment by a domestic violence counselor. And that is not the job of the guardian ad litem. The guardian ad litem's job is to assist the court to gather information and to provide data to the court. And in order to be able to do that, has to appear and be objective and independent. And we have a concern that in a atmosphere that is already full of conflict, we're putting a duty on the guardian ad litem that may appear to one of the parties to be a bias towards the other. By referring somebody to counseling, that is a step towards having a more active role in the case itself, as opposed to that statutory role that's described that I mentioned earlier. And then with regard to the lethality assessment, in addition to whatever confidentiality questions that may exist as to the content of that lethality assessment, it does create another burden on the GAL. It does create an expense. And really the information that is contained within that lethality assessment is a tool for the police to make a determination on a very short-term basis on what are some risks involved in a particular situation. The content of it is typically, if you have a good GAL, the GAL is going to obtain that information anyway and be reporting to the court, that and more in terms of the information. So I think one is not necessary, and two adds a burden and an expense to a guardian ad litem, and is an additional delay in a proceeding. With that, I'll be happy to take any questions and refer you to my written testimony filed yesterday.
Thank you, Mr. Head. I do have one question from Representative Josh Yokella.
Thank you. And thank you for taking my question. It was mentioned before that GALs may be requested by or chosen by applicants. I wanted to see if you could expound on that and how often that happens, and just information.
Sure. So frequency, I honestly don't know. I don't dive into those details. Certainly, if there is a guardian ad litem that is qualified, that the parties want, that is who would be the guardian ad litem for the case. So it does happen. The frequency, that's the preference. But truthfully, I don't practice in the family law, and I haven't seen sort of data on how guardian ad litems ultimately are being identified and put into a case. But preference would be obviously if the parties select a guardian ad litem, that's at some level into a better route. But I don't know the data on that.
Thank you. The next question will come from Representative Belanger.
Thank you, Madam Chair, and thank you, Mr. Head, for taking my question. You alluded to unintentional bias from guardian ad litems, which I have seen as well, in their decision-making process. You said their job is to assist the court and gather data and must appear objective. I guess how often are you seeing this, and how would you suggest fixing that?
I guess my point was, as to this bill, I think it's as to this bill, which would require the guardian ad litem to be the one to direct or to refer, I guess is the word, the party that making the allegation, or when the guardian ad litem suspects it, is taking an affirmative step which would appear to the other side to be taking a position, which is, I've now, I as the guardian ad litem suspect that domestic violence has occurred here, and I'm going to take the affirmative step of referring that person to counseling. It very well intended. I'm not saying it's not. But what I'm saying is that the other party, who very well may be challenging domestic violence, is going to see that act as taking sides. Certainly in the report to the court, there's data that has, that presents a view on the situation. But the investigation itself, and this would really be triggered during the investigation, because if it's alleged, then there's a referral, or if it's suspected. So if during the course of the investigation itself, the guardian ad litem suspects domestic violence, that would have to require a referral, and that act is essentially an act in the midst of a independent and unbiased process. So I think it's creating an opportunity for just further friction in a difficult situation.
Thank you. Representative Altshuler, do you have a question?
Thank you, Madam Chair, and thank you, Mr. Head, for taking my question. I'm wondering if you could give me your opinion as to on Ms. Jacina's assertion that this bill as written could possibly breach the confidentiality of a crisis center advocate and a survivor, if this referral were to come from a GAL and then further put in an official court report.
I guess so I don't have an opinion on that. I don't. I'm trying to think it through what would be the circumstance where that would occur. Certainly, if the crisis center or counselor became a witness that essentially is identified as a person now with knowledge and a witness, that creates some conflict. But I honestly don't. I'm not sure. I think it's probably a better question for Attorney Justina.
Thank you. Any more questions? Thank you very much.
Great, thank you.
Seeing no more hands and having nobody else on the list and no more questions, I will close testimony for House Bill 548. We had 16 support, opposed 2, and we had 5 people testify. According to my list, those numbers could change. And I will thank Representative Long for his patience. And we will open testimony for House Bill 460. And I will begin this portion of testimony with Representative Long, who I'm sure would like to introduce his bill.
Thank you, Madam Chair, and I'll wait for Madam Clerk when you're ready. She put up her finger sign to hang on a minute, so.
Yep, I'm trying to get to you so quick because we're 32 minutes behind schedule, but I'll give Representative Alisea all the time she needs.
Okay, thank you. I just need like a minute in between to get the paperwork.
Okay, I'll try to remember that.
Okay, thank you.
Okay, so thank you, Madam Chair. For the record, I'm Representative Long. I represent Hillsborough District 10 within the city of Manchester. House Bill 460 came throughout the years on this committee of trying to get our fingers on how would this bill affect the other cases. We hear of issues that we're looking to fix. However, when we fix those issues, the following term we hear different issues that came from that first issue that we fixed. So so the study would be working with the circuit court to see if we can't get more information when we need it. A lot of times we'll hear bills and we need information. We're going to exec in 3 days and we just don't get that. I know when I first started on children and family law, there was a circuit court person assigned to us that had all the information that we needed, even on information that they don't relatively keep data of, but they would go and look up some of the data, maybe take a 25% reading of it and give us an example. So that way we could have a little bit of a pulse on the bills that affect the other cases and how it would reduce or increase conflicts. I know myself for years on this committee, I've always tried to look at every bill on the possibility of increasing or decreasing conflicts. Those are something as a representative, I want to be sure I'm not passing legislation that increases conflicts because that's not what I want to do. So this is relative to determination of parental rights and responsibilities. For example, bills with respect to co-parenting. How many are there? How difficult is this? I suspect that there are a lot of co-parenting issues, but I don't know that. It's just what I guess from talking to constituents or whatever, and that may not be the case. So although this is with respect to determining parental rights and responsibilities, as we heard today, there's a lot of questions that we have, and I'm grateful for Mr. Head being here, because that is also helpful to have a representative here, but to work with the circuit court to see if we can't come up with a way to get, in my mind, some imperative information with respect to decision making that we have in this committee to, not only help us to make informed decisions, but to relieve the circuit court of issues that they have in judging. I'm sure they would much rather have it clear and concise than, because what happens is other, judges determine different, read the law differently. And so, we've heard over time where, one parent will come in with an issue where another judge in another court totally took that differently. So, helping both the circuit court and children and family law come together with a, with a conclusive, informed decisions for us and a better managed circuit court for them is why this bill came up. So, thank you, Madam Chair.
Thank you, Representative Long. I have one hand up for one question. Well, now I have two. Representative Belanger, you have a question?
I do, Madam Chair, and thank you, Representative Long, for taking this question. I see the 3 members of the House of Representatives appointed by the Speaker and 2 members of the Senate appointed by the Senate President. When taking into consideration establishing this bill that would establish a committee, did you take into consideration judges, as I feel they may imply a good, they may be able to provide a good input in this?
Well, committees are normally, thank you for the question, Representative Belanger. Committees are normally legislatures. The Senate more than likely is going to say 1 member, you know. So it's usually legislatures on committees. Commissions, then you would invite, I mean, a commission would be great if we could even invite, parents that have been involved. But I think, I think that's on a broader base. But with respect to parental rights and responsibilities, I think, I think the legislature, I know Mr. Head will sit with us. I know Judge King, is it, would sit with us, because it'll help both of us. It'll help them as well as it'll help us.
Thank you. Representative Yokella?
Thank you, and thank you for taking the question. It's my understanding thus far this session that people are not willing to establish committees that are going to report this year due to the lack of ability to meet in person this year. And it seems like this is also a perennial issue. So it seemed that you would be in favor of creating this more of a standing commission to, hear issues in the family court. Would you be amenable to an amendment such as that?
So thank you for the question, Representative Yokella. I'm not privy to what's going to make it or not going to make it. So maybe you could have your people call my people and we could, but I think a commission, this was, when I put this in, it was parental rights and responsibility only. I figured I'd take a bite instead of going after the whole picture. A commission, commission would take longer, I think. I think this is going to be relatively simple and expedited because, the circuit court knows what they want and the legislature knows what they want. So it's just a matter of where we're going to compromise and get it done. So, but yeah, a commission, I'm open to whatever the committee thinks would be in the best interests of the family court and children and family law.
Thank you.
Thank you. And then we will move on to one more person wants to testify. Mr. Richard Head. Can you unmute him, please? Mr. Head, go ahead.
Great. Thank you, Madam Chair, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. We take no position on this bill. I just wanted to offer 2 things. One, I've only been on this job since November, but you should, in hearing what Representative Long said, always feel free to use me as a resource if you need data, preferably before a hearing. I can ask people to extract data out of our Odyssey database if it exists, or get more general information from people with experience. So one, I just offer to the extent, without regard to what happens on this bill, if it passes or doesn't pass, feel free to use me as a resource if you need data, and I'm happy to do that. Secondly, the COVID has affected sort of normal processes. I think normally the judicial branch, and depending on the committees, there's usually a introduction and discussion of issues and topics at the beginning of the first year of a session. And that didn't happen this year, and I think it's incredibly productive and useful. And maybe if this bill does not go forward, and if there are in-person meetings going on at the beginning of next session, maybe there'd be a delayed opportunity to do that with this committee. But other than that, I'd be happy to answer questions.
Thank you, Mr. Head. Any questions? I see none.
Thank you.
And at this point, I will close the hearing on House Bill 460. And thank you all for your perseverance and your assistance and your help today. I hope tomorrow will go a lot smoother. I got it, I think. So thank you all. Get some rest. Be ready for lots of work tomorrow, like you were today. And we'll
So
see.
Madam Chair, are we expecting to exec bills tomorrow? We're not. Okay. Thank you.
You're very welcome.
Madam Chair,
Well done,
Mr. Head
Jay.
has his hand raised again. I'm not sure if that's on purpose or on
I'm
accident.
sorry, Mr. Head. Just put his hand down. Representative Altschuler, did you have a question or a comment?
Oh, I just said, well done, Madam Chair. Thank you.
Well, thank you.
Yeah.
Thank you all. See you all tomorrow. Have a good afternoon. If you're driving anywhere, be safe. If you're going anywhere, be safer.